6-3 DM Bly v. Bly. This is a divorce case. There's also a, oops.
No.
It's what? You think it's working? We're just making sure that it's recording like we have to. All right. And there is a companion case, a DES case. However, there's a motion filed by the plaintiff mother to find that the child, Landon, is born out of wedlock, and she's asking that order be entered. I do have, I believe I have a paternity test here that shows that Mr. Bly is not the father. Yes. Mr. Bly, do you object to this, the child being found to be born out of wedlock?
No, I do not object.
Do you have any relationship with Landon?
I do not, no.
All right, ma'am, is there anything you wish to add? Well, we can enter the order that he is born out of wedlock, and then that will be out of the DM case, the divorce case. I think, if I recall, there are still two other children that are, no, there's one other child, Kyle, that is still part of the divorce case. Is that correct? With no objection from either party, we'll enter the order that the child Landon is born out of wedlock. Ma'am, what are you going to do to legitimize Landon? Do you have the father?
Yes, I do. I have the affidavit signed and ready for.
The affidavit of parentage?
Correct.
All right. We'll get this out as quick as we can. So that'll take you off of it, sir. And I do want you to file that affidavit of parentage as soon as we get this order out to you. Okay.
I will.
Thank you both very much. Anything else?
Nope, I'm good.
You nope.
All right. Thank you. We're adjourned. Gomez versus Colton. We have Mr. Colton, the defendant present. We have from the prosecutor's office, Mr. Hahn. This was scheduled for 8:30. It's about 8:39. Miss Gomez has not appeared on Zoom or in the courtroom. And this is a request from the prosecutor's office, represented by Mr. Hahn, for a judgment of support. It shows 61 overnights. Mom has potential income of 17 hours, $17 an hour for 40 hours, because that's what her prior work was. She does have some additional children that she's given credit for. Father works $15 an hour times 40 hours actual, and the prosecutor is asked to enter a judgment of support in this matter. Is there anything you wish to add at this time, Mr. Hahn?
Just briefly, Your Honor, thank you. This case was filed on November 17th of 2023, and service was proper on the defendant on December 7th of 2023. Our office did receive a response from him on December 12th of 2023. Your Honor, I did schedule and hold a pre-hearing conference. I was unable to get a hold of Miss Gomez. I did call and leave a voicemail and requested that she call me back, but to date she has not. I did have that pre-hearing conference, however, with the defendant, and received all of his information. He did express parenting time and custody concerns. I explained that he is more than welcome to file his own motion in this matter, as our office does not get involved in those issues. Your Honor, the plaintiff did request back support in this matter when our office initially interviewed her when we initiated this case. As such, the effective date of the child support order is December 1st of 2023. I do believe the documentation, Your Honor, is appropriate, and I'm requesting entry of same. Thank you.
Thank you. Mr. Colton, is there anything you wish to say?
I just feel like, since it just kind of tough on me right now, because ever since my child was born, I've always been there taking care of him and stuff, and ever since me and her separated, it's just been a lot of things that have been going on pretty much that like makes me feel like she's unstable of taking care of my child and stuff. I've had several, cases of CPS getting involved for her neglecting them and stuff. So
well, you can work with CPS on some of that too.
This was when she was living at her grandma's house out there in Saginaw, Michigan at that time. But now she's in Grand Rapids, Michigan, living with her sister right now.
Well, as the prosecutor said, this is only for a judgment of support. They cannot go into custody parenting time other than they give the initial custody of the child to the mother. However, that is without prejudice to determination by the court of the custody of the child. So in other words, if I have to determine custody, and that has to be by a separate motion that you have to file, because they're not involved with that. They're representing the state The
Right,
mother,
I understand.
mother's clearly on state assistance, so they have to make sure that support is paid, all right? And all right, well, he was not served till December 7, I think. He's been involved. The only thing that I would like to make a change to, Mr. Hahn, is to start at the 1st of this year,
January 1st, is that correct?
as
Okay,
opposed to December.
absolutely, Your Honor.
All right, so we'll start at the 1st of the year, sir, and enter the order. I expect I'll see you in my courtroom probably sometime in the near future. I can't give you any advice, but I will give you this advice. You should seek the advice of an attorney. They're who knows what they're doing. They're family law attorneys who are very good at this and would be a world of help to you.
Okay, sounds good.
That's just the way it goes. Good luck,
Yeah.
everyone. Thank you very much. We're
Thank
adjourned.
you, Your Honor. I'll have the those documents amended and I'll send it to you via DocuSign for signature today.
All right, thank you.
Thank you.
How have you been?
Me?
Mm-hmm.
I've been good. How about you?
Doing good.
How's the missus?
The missus is still putting up with me.
Nice,
She
nice.
allows me to come home at night and stuff like that.
That's amazing. So you're not sleeping outside. That's great.
Well, so far so good. Cold out there, but you know, everything's going well. My son leaves for Hawaii today
Oh, wow.
for his job in the World Surfing League. So he's got to spend 2 weeks in Hawaii. Awful job.
Oh, that sounds terrible. He
Yes.
sounds like he's gonna be so sad.
No kidding.
That's incredible though. What great work.
Hunt v. Coleman. We have the plaintiff, Ms. Coleman, present via Zoom. Mr. Hunt has never logged in. It was scheduled for 8:30. It's about 8:47, and he has never logged in at all, nor has he shown up at court. This is a request for a judgment of paternity made by the prosecutor's office, who is represented by Mr. Hahn here today. There is a DNA test. No, there is an order for DNA testing on 12/15/2023. Mr. Hahn, where are we at with this?
Your Honor, was the DNA results, were they not filed with the court?
No.
Oh, goodness. Well, we did have DNA results come back that he was found to be the biological father. I apologize that our office did not file those. I'll have that filed as soon as I can once I'm off the Zoom. Your Honor, the defendant is the biological father of the child in this matter. He is also currently incarcerated in the Kent County Correctional Facility. The judgment and UCSO before you, Your Honor, establishes paternity, but also reserves the issue of child support, making it a 0 child support order until such time as he's released from incarceration. Your Honor, I do believe the documents are appropriate. Again, I apologize that those results were not filed with the court. I will have that done immediately. But I do believe that the proposal before you is appropriate at this time. When the defendant is released, then child support can be redetermined by friend of the court so that Ms. Hunt can have the financial assistance that she needs.
Right. Miss Hunt, is there anything you'd like to say? He is deemed to be the father now, because we do have a DNA test that shows he's the father. I assume you knew he was the father anyhow. And as the prosecutor said, we can't get child support from him while he's incarcerated. Do you know how long he's expected to be in jail? Oops, can't hear you. Do you have you can shake your head yes or no. Do you have any problem with these orders being entered? Okay, and you are aware that when you know that he gets out, all right, from incarceration, you should contact the friend of the court and tell him that, because you'll have a copy of this, you should contact him, tell him he's out of jail or prison. I'm not sure where he is right now, but and tell them that, and they should start an investigation to get you child support. Okay. I'm sorry, I can't hear you. I'd say, is there any questions you have, but I don't know what good that'll do unless you're going to write them on a piece of paper. Okay. Thank you very much for being here, Ms. Hunt. We will get these orders entered. You'll get copies of them. Okay. Thank you very much. Have a good day. Thank you.
Thank you, Your Honor. And just to clarify, he is in the Kent County Correctional Facility, not in an MDOC.
Do you have any idea how long he is supposed to be there?
No, I don't, Your Honor. The last I knew, he
Holding
was.
up 7 months. Is that correct? About 7 months. All right. All right. I'm going to kind of leave it up to you to know when he gets out. Okay. Thank you very much. Take care, everyone.
Thank you, Your Honor. I'll have those sent to you via DocuSign. I'll make sure my clerk sends a copy of the results down.
All right. Are you still treating your husband nice?
Me?
Yeah.
Sometimes. Depends on the day.
That's what I figured.
We're still married, so I must be doing something right.
Yes, it must be. You've made it. How long has it been now?
A year and a few months now, I want to say.
I'm almost at 2 years, so
I'm right there behind you.
whew. It's working out so far.
I think he just likes me for my cooking. That's probably why he stayed with me.
That are you a real good cook?
I don't like to eat out very much just because I don't really trust people to not like, rub their noses and then touch things. So yeah, he's eaten much better now that we've been married.
Well, I do all the cooking in our house, so
Oh,
maybe
nice.
that's why she sticks around.
I'm telling you, food is the ultimate love language.
Yes, it is. All right. I wish you all the best today. Have a great day.
Thank you. You as well. Have an excellent
Parties are
weekend.
present
See you
via
again
Zoom.
soon.
It's a motion that was
Bye-bye.
filed by the plaintiff, Ms. Garza, to enforce a judgment of divorce. He was, in his judgment, Mr. Garza was to pay 60 months at $328 a month to pay off the equity in the home. It also called for him to assume the Lake Michigan Credit Union debt in the amount of $6,949. Ma'am, you're saying that he has not kept up with the 328 a month, is that correct?
That's correct.
How much is he behind? I mean, you sent in these, I can't decipher what you sent in. And I mean, I can just look at 1215 and 15. It talks about a restaurant and Chubby's bar, and I don't even know what the purpose of it is. Southside Social Tavern, Buddy's Civic Center. Nothing has anything on it that pertains to me.
Okay, so since our divorce was final in April 1st, 2020 was when he was supposed to start making regular payments.
And I totaled that should be 46 months. That should be $15,088.
Correct, but to date, which is February, if you include February, his payment should be, he's paid so far $7,527. And so the balance remaining is $12,137.
All right, and something about Lake Michigan Credit Union is his. Why are you making payments on it?
So it's a joint account that we had while we were married, and last June I was surprised to find out they just took the money out of my savings because they said I'm responsible if he's not making the payments. And so for the past 8 months I've been making the payments
How
of
much is that total?
it totals $1,700, but he paid me back $420, so it totals $1,350.
Sir, do you agree with those numbers or what? Mr. Garza,
Yes, yes.
why aren't you making the $328 a month? I mean, I got to do something to you if you're not going to do that.
Right. I mean, it's been a tough time ever since the divorce. I've been tasked with keeping my home since the divorce. When our two boys who are in college,
And
they've been staying home, but
I don't want to sound
nonetheless.
unsympathetic, but you
No,
signed the judgment and it says you'll do it, then I got to enforce it. If you were 2 months behind, I'd just say catch up, but I don't know what to do when you're.
Well, and here's what I've done. And I don't know how to address you. Are you a judge, or I'm not sure.
Referee, you just be respectful, please.
Absolutely. Well, what I've done is I've gone and collected and borrowed money, and I have enough money today to get to the point where I'm current. Okay. I've gone to Lake Michigan Credit Union, and I've set up an account, so that account that payment comes out automatically out of my savings there. So that'll be done. So Sue won't be bothered with any notices or late notices, or I'll have to make a payment. So as of today, and however she wants me to pay her, we either cashier's check or cash or however, I can catch up to through February.
Okay, so, ma'am, how do you want him to pay you?
Well, he can just go into Lake Michigan Credit Union and he has my name and my date of birth and my address, and they'll be able to find my account and he can just deposit that amount in there.
All right. Does that work for you, sir?
It does.
Can you
Yes,
also-
it does. But and one thing I would like to do is so like I said, I have all this enough money to be current. But what that does to me, it for lack of a better term, it bleeds me dry for the next month and a half. So yeah, I know there's a payment due in March, and I'd like to not have to make another payment to Sue until the end of April, because I'm just gonna, you know, I'm using all the funds that I have available to me right now to
All right.
come even with her.
But, I think what we'll do is we will adjourn this motion potentially for 4 weeks, okay? So that it makes sure that you follow through on what you said. Okay,
Yes.
that the funds get in there. Ma'am, obviously, if he doesn't follow an order, he's basically in contempt. If he brings everything up to date right now, he'll have paid basically 46 or 47 of 60 months payments, okay? And if he continues, if he misses a month, you gotta, Mr. Garza, you gotta keep her informed of everything, okay? I mean, you must have a way to have some contact. I mean, do you have a text or something like that where you can
And
just
we do, and
email?
yeah,
and-
yeah, we do have that, and some of the times that I missed, I did inform her of that, and she
Okay.
was okay with that. But nonetheless, like I said today, I want to come even with her and go forward.
Ma'am, why don't, let me leave it to you, ma'am, that if further problems arise, you can just renotice this motion. Okay,
Okay,
you won't have to pay a fee or anything, just renotice it. All right.
okay,
And obviously, if you come back 1st of April saying that he hasn't made a payment, and he's already told me he's not going to be able to do it, but he will continue on from there. I don't know how much. I'm just trying to get it paid, sir, and in a reasonable manner. It doesn't. I mean, she waited. You were way behind before she even filed this, so I'm assuming that all she really wants is to get paid. So I'm just gonna. I'm gonna leave it at this point that we will adjourn this motion until a later time. If you renotice it, ma'am. Okay.
Okay.
I'm not gonna set a specific time. Hopefully the two of you can work enough and get this paid off sooner rather than later. If you have taken those steps, sir, at Lake Michigan Credit Union, make sure that you give her enough information so that she knows that that's been done, okay? You
Do you
say
mean as far as the
taking it
I
out of your
understand as far
savings and so nothing more comes out of her account, okay?
correct? Right.
Communication is gonna be the key here. I don't really see Miss Garza as being evil and chasing you, but she did get way far behind, and I'm sure she depends on the money just like you are. Hopefully you can work everything out and be done with this, but we will just adjourn this motion without a date. And if you don't come through, she's gonna come back, and I'm gonna probably do something like a money judgment where she can start garnishing your wages and stuff like that.
and that
Okay.
is something I would prefer not to do,
Oh, I'm
but
sure. No,
it's- yeah.
I don't want you to have to do that, and I don't want him to have to happen to him, okay? I'm
Right.
just saying, let's just get it done, and she'll be reasonable with you, sir, as long as you know, keep her in the loop and keep going and get it done. You're not too far from paying everything off, so that'd be good, all right?
All right.
All right, that'll be the order. We'll just adjourn it without date and wait if we need to. Hopefully, we won't need to see you back. Thank you.
Thank you.
Keys, can you
Okay,
hear me?
thank you.
Is he connected? Because he's driving.
He's connected.
Sir, can you hear me? You gotta pull
Yeah.
over.
Yes, I'm finna pull over now, sir. I was just
Thank you.
leaving the courthouse. I thought I had to be there in person.
That's all right. That's right.
All right.
Pull over and we'll be fine.
Okay. I'm gonna pull over here 1 second.
Thompson versus Keys. We have Ms. Thompson and Mr. Keys both on the, on Zoom. We're waiting for a moment for Mr. Keys to be able to pull over so that we can do this. This is a request by the plaintiff for child support. It's my understanding at this point that there is no child support order. Is that correct, Ms. Thompson?
Yes, sir.
All right. Mr. Keys, I read your response, everything. The state of Michigan basically requires that, I set child support. I don't know what it should be at this point. My thought is I'm going to refer it to the friend of the court for both parties. It looks like your son is 17 years old. Is that what you said, Ms. Thompson?
Yes, sir. He just turned 17, December 13th.
Yeah, well, child support will be due, sir. As long as he's 17, it can go on longer. If he is in school full time with expected graduation, it can go till 19 and a half. I don't know anything about that. Anything you want to briefly add, sir? I'm just going to send it to the friend of the court for them to make a determination.
No, I mean, that's the decision. So I guess that's just what it is.
Because they'll look into it. They'll look into your wages, her wages, who lives where, how many overnights, all this kind of stuff. They'll send me a recommendation. If you disagree with it, make sure when you get it that you read it, because you can object to it if you think there is something wrong with it. But if you don't do it in a timely manner, it will be entered. They will contact both of you to provide information, financial, as well as how many overnights and other children and whatnot. Okay. They'll do their investigation. I just want to make sure that both of you cooperate with them so that we can do an accurate assessment. I'm not going to say your full names or your full address because we're on YouTube, but ma'am, you are at 255. Is that correct?
Yes, sir.
I just want to make sure that the friend of the court, sir, you are at 2224.
Yes.
All right, then they'll send out information to you. Please cooperate. Otherwise, they do it without your cooperation. They'll figure out the best they can.
Yeah.
So
Yes, sir.
we'll send it to the friend of the court and let's see what comes back. All right. Thank you.
Thank
you.
Thank you both
Yep.
very much. It's the matter of Jones v. Freeman. We have Mr. Freeman present via Zoom. We have the prosecutor, Ms. Rummelt, also present. This is a request from the prosecutors regarding a judgment of paternity. It appears that when the case was filed, that the defendant, Mr. Freeman, admits that he is the father of Joel. So we would enter a judgment of paternity on that. There's also a uniform child support order that is requested to be entered. Mother has actual income of $17 an hour times 32 hours. Dad has potential income of 1033 times 35 hours. Ms. Rummelt, is there anything you would like to add?
Simply that the birth costs in this matter will be waived and the effective date will be December 1.
All right, so waive the birth costs. Mr. Freeman, is there anything you would like to add?
No.
All right, so what we will do is we will make you the legal father at this point, and there will be a child support order entered that calls for $160 a month at this point. All right?
Okay.
All right, we'll enter that, Ms. Rummelt, as soon as you send it to me by DocuSign. Thank you very much, Mr. Freeman, for being here.
Yeah, you're welcome.
Thank you.
Thank you.
Okay, yeah. So it's over?
I think he was saying goodbye.
He said, is it over?
Yeah.
Yeah.
Didn't get a chance to respond, but both our matters. All right, yes, and there's Miss Brittany Todd White against Mr. Terrell Johnson. Miss Todd White is present, as is Margaret Rummelt from the prosecutor's office. Mr. Johnson has never checked in. It was set for 8:30 and we're almost at 9:15 and he has yet to check in or show up at the courthouse, my courtroom. There are two cases. One is a judgment of paternity, I assume, where he is 99%. There's also a support request for a judgment of support. Ms. Rummelt.
Thank you. I'm asking that a judgment of support, a judgment of paternity, and a uniform child support order be entered. The DP file will be consolidated into the DS file and support will be paid through that DS file. Defendant was served on both of these matters on August 30th of 2023. He filed an answer requesting genetic testing in the DP file. Testing was completed and established he's the child's biological father by genetic certainty. Pre-hearing was held on January 16th in both matters. The parties participated. I would like to note that defendant does live in Arizona, or at least did at the date of the pre-hearing, which maybe explains why he's not here. I'm not sure what the time difference is, but he did
Probably
receive
6 to 15 out there, but
yeah, he did receive notice of this hearing. Child support is based on plaintiff earning an actual income of $29.54 an hour, working 40 hours a week, which was verified. She pays $84.34 a month in health care. She's paying $225 a week in childcare, which was also verified by the provider. And she has 365 overnights and one other child. Defendant's earning an actual income of $30 an hour, working 40 hours a week, which was verified by the defendant. At the pre-hearing, he has no overnights and 3 other children. The calculation resulted in base support of $815 and ordinary medical of $34, and then $395 in a child care contribution, for a total order of $1,244 per month. The uninsured medical split is 55% to plaintiff and 45% to defendant, and the effective date of the order is September 1. Birth costs are waived.
all right. Ms. Todd White, is there anything you wish to say or anything about this matter?
No.
All right, to the best of your knowledge, he continues to live in Arizona, I take it.
Yes.
Okay, and he does not have any overnights with Kingston or Princeton, is that correct?
Mm-hmm.
Okay, all right, well, it does appear that the orders are appropriate, having calculated per the child support guidelines and clearly per the DNA test, which is 99.99999% certainty of paternity. I will enter both orders if when presented with DocuSign.
Thank you very much.
All right, Ms. Todd White, anything you would like to say?
No, Your Honor.
All right, well, you should get those orders out pretty soon. All right, you'll get a copy.
Yes, thank you, Your Honor.
Thank you. Thank you. Thank you, everyone. Davis versus Samuels. As we have stated here, for the record, both parties did log on. This was set for 8:30. It's now 9:17, and both parties did log on, but apparently logged off, and I don't know where they went.
Your Honor, I might have a note on that, possibly. Is this 163? Yes, we got a message. The custodial parent, Ms. Davis, called. She was logged into the Zoom hearing this morning, but she needed to leave to take the children to school. And he will be leaving the Zoom as well. They wanted to know if they could reschedule.
Taking the kids to school what are your thoughts, number one, on rescheduling, but also if you could contact and tell them to log in at 10:30 and we can do it then. I'll still be on the bench, I'm sure.
I will certainly try. And we can all log back in at 10:30, Your Honor. This is a deviation. This is kind of a little complicated only because there's another order for another child in another county. And so I mean, that really doesn't have anything to do with whether we adjourn or reschedule, but I will try to reach the parties and I will log in at 10:30 and let the court and make the court aware of what I know. Okay.
All right. Good. Thank you very much. We'll see
Thank you.
back then.
Bye-bye.
Ms. Birch, can you hear me?
Yes.
All right. Do you have a camera? Video?
Yes.
If you could turn it on, please, we'll start the case. 7DS. Birch v. Jackson. Ms. Birch.
Yes.
Ms. Birch is present, but working to get her video working. Mr. Jackson is not logged in.
They know you. From device menu setting. Privacy camera. Okay, I'm trying to go to the settings and fix this because it's in privacy mode.
Ms. Birch, did you send him a copy of this motion?
Yes,
You know when?
the day that it was filed.
You say that you say that you mailed it to him on the 23rd of,
Mm-hmm.
is that correct?
Yes.
You put it in the mail for him?
Yes.
Have you heard from him at all?
Nope.
All right, well, she did file a certificate of mailing, proof that on this date, it served a copy of the motion and notice on him on 1/23, and that's significant time. He has not logged on or been on in any way. This is Birch's motion for child support, says that the father is working at Spartan Nash Foods at $23 an hour or more. There was the last UCSO in this case was from August 13, 2021 for $83 a month. And I think that was for imputed income. It also showed at that point that the parties had 50-50 time. Ma'am, you no longer, he doesn't have 50-50, he doesn't exercise it, is that what you're saying? You're on mute, does he see the kids equal time?
Nope.
All right, then what I'm gonna do is I'm gonna send this to the friend of the court for a child support determination based upon the added money that he's making way more than twice as much as when we last calculated his child support and has significantly less time. Ma'am, they will contact you to get the stuff that they need from you, the friend of the court will. I don't want to read the address, but all of it, but are you still at 745? That's all.
Yeah, I'm still at the 745.
Okay.
And he I don't know, he might try to file a motion. I don't think he's gonna do anything. He just kind of like set my daughter on the shelf when there were allegations. Well, my daughter had brought it up to me that she was like assaulted. So after that, he just didn't come around anymore. He just didn't.
Right, well, yeah, this is just gonna be a child support motion, and you will talk to the friend of the court and make a determination on how many overnights, how much you make. They'll contact him. If he doesn't come back, we'll figure out how much he makes and come up with an order. The friend of the court will recommend an amount, and you'll get a copy of it. He'll get a copy of it. If either party disagrees, you can file an objection and we'll deal with that at that time. But I want you to make sure that you cooperate with the friend of the court or they will dismiss this, okay?
Okay, all right. So just be looking out for paperwork in the mails, essentially.
Look out for the paperwork. I don't know if they even contact you through email, if they have your email, but look out for a friend of the court information. They'll ask for certain things, cooperate with them. I hope Mr. Jackson will, and we'll deal with it from there. All right?
Okay, thank you. Have a great day.
You too. Thank you very much. It is
Bye-bye.
Castro Reyes versus Joshua Castro. This is both. Mr. Castro, the defendant, is present via Zoom. You can hear me all right, sir?
Yes.
All right. And the plaintiff is not. Sir, how did you get her notice of this hearing?
Hey, when I was there, I say if somebody speak, like it can translate.
Did you send this to her or something?
Yeah. I gave it to her 1 papers.
You gave the papers to who?
To normalize.
To the mother?
Yeah.
When did you give them to her?
The same day I did the papers.
So you walked over and saw her at that time?
Yeah.
Okay. Well, she is not shown, and it's apparent that that she did have notice of this. There are 2 motions filed by the defendant, one for parenting time and one for taxes, to claim the child as taxes. There was a judgment of paternity that was entered just about a year ago on 4/26/2023 that did not contain anything about parenting time. Are you guys doing anything with parenting time now? When do you see the child?
I see him like Tuesdays, Thursday and Friday.
And this is just something that you guys agreed to?
Yeah. So for now, but now I wanted more days with him and I want to try to he stay here with me.
Well, that'd be a custody motion you'd have to file, and we'd have to have an evidentiary hearing on that. You say that right now you are visiting. When do you see him? On Tuesdays and that
Yeah.
kind of
Tuesday, Thursday, and Friday.
Tuesday, Thursday, and Friday?
Yeah. He just stay with me like 5 hours before I go home. I go to work.
Okay, but yeah, pretty soon. Is he like 3.5 years old or something?
Yeah.
Okay, and when, I mean, during the Tuesdays, Thursdays and stuff, what times do you see him? When do you go to work?
I leave like 2:30 to work, and then start like 2:45.
Okay, so you get him in the morning till you go to work,
Yeah.
and then and those times. Do you get any weekend time?
No, I want to try to do it like that.
Do you work on the weekends?
No.
All right, I guess we can set up as a temporary order. I wish she was here to figure out what was going on. I think it's appropriate that you would probably get every other weekend. Is there any reason you couldn't get every other weekend?
No, it's good like that.
When do you get out of work on Friday?
Like 2:45
2:45 in the afternoon or in the morning?
afternoon.
Okay.
But I mean, I can give it to her, his grandma, and then when I get out to work, I can go for him.
Well, I'm just trying to figure out so you can spend time with your child as much as possible. Okay, it doesn't do any good to give you 8 hours while you're at work. All right. You go to work at 2:45 on Friday.
Yeah.
That's 2:45 in the afternoon, right?
Yes.
And so you get out what, midnight or something?
11:30.
All right. Why don't I do every other weekend, Saturday at 9 o'clock to Monday at noon. Okay. That you can be available all that time, can't you?
Yeah.
I want you to spend time. I mean, obviously you're going to have help and stuff like that. It's not to say your mom can't help out and stuff, but basically I want you to spend time. That's why I'm setting it up that way, is if you want to spend time with your son, now's the time to do it. I will also give you at this point, I'm going to give you every Thursday from 9 in the morning till you normally take them back somewhere around 2 or something like that.
Yeah.
2:00 p.m. And then I'm going to also just refer this to the friend of the court for a parenting time evaluation. They'll make some kind of a recommendation as to what's appropriate or something. Okay. Now let me just look here for a minute. This was a DP case. Have you ever had a custody determination?
What is that?
You've never been in front of the court for this, have you?
No.
All right. And you're telling me that you want the child to live with you?
Yeah.
The order from the paternity case states that the plaintiff shall have physical custody of the minor child until order of the court. That was from less than a year ago. That's just sort of a temporary thing, so I'm going to refer it to the friend of the court for custody, parenting time, child support, do all that kind of stuff. Okay.
All right. Sounds good.
I can't tell you what they're going to recommend, but if you don't cooperate with them, it won't go good for you. Okay. They'll be in touch with her too. And we'll leave it at that. At this time, I'm going to deny your request regarding taxes because the IRS has that figured out. If you get it, you get it. If you don't, you don't. That's not something that at this point I'm going to do. If we come back at a later time for something, you can always ask for it, but I don't know what the friend of the court's going to recommend. Okay. So that kind of stuff. So I'll refer it for custody, parenting time, and child support. As I say, once they complete that, they're going to probably send through a recommended order. If you don't agree with it, you only have a certain number of days to disagree, or the order will be entered. All right. So I'm just telling you, cooperate with the friend of the court, make sure that, you give them what they need and everything, because they'll let me know if you're not, and it doesn't go good for people who don't cooperate. Right, and, we'll move on from there. I don't want to read your whole address because we're on Zoom, but is it, let me see, 6146, is that your address?
Yes,
All right, just making sure so that the friend of the court will know that, and you're sure that her address is 434, is that right?
yes.
All right, you can inform her that what's happening. It won't be this weekend you will start, it'll be the next weekend.
All right, sounds good.
All right, good luck. If the two of you can work stuff out, put it in writing and send it in the court, okay? If you guys can work stuff out, all right?
All right.
Good
All right,
luck,
thank you.
thank you. We're adjourned. Hello, everybody out there in YouTube land. We'll say hello to Cheryl and Missy. See, Jody might be logging in, I heard for the first time. If so, good morning to you. Emily, Sharon, all the people out there in the world. Ms. Piotrowski, can you hear me?
Yes, I can hear you.
Thank you. I apologize for the delay.
That's all right. You've done worse.
True.
All right, we're here in Piotrowski versus Piotrowski. 15 parties are present. Mr. Piotrowski has Mr. Reams representing him. This is mother's motion, in essence, for an evidentiary hearing. There was an order a while ago that I stated that, you know, we were going to have a GAL appointed. Miss, if I recall, Renee Wagner was appointed. We'd look over the GAL report and recommendations. It was my hope that the parties, once they dealt with Miss Wagner, that they would kind of be able to figure this thing out. We're dealing with Serena, who is, I think, 16.
Yes.
And I was hoping that we'd be able to work some stuff out on this. The report that I saw, and I'm assuming both parties saw, kind of recommends 50-50. And I'm going off of memory now, kind of on a 2-2-5 type of schedule. Mother claims that the GAL is biased. I'm not sure where you're going with that, but you'll get your chance. And so since they haven't reached any kind of an agreement, she's asking for an evidentiary hearing. Correct, ma'am?
Yeah, that's correct.
Mr. Reams, anything you want to say? I mean, the order kind of called for an evidentiary hearing after the GAL report, and so I think I kind of got to set up an evidentiary hearing. Any thoughts from you, sir?
While I would like to disagree with you, I cannot, Your Honor.
I know you prefer to disagree with me on any chance you get, but it appears that I just have to set up an evidentiary hearing on this as far as addressing other issues of child support and stuff like this until the time comes. My order still stands. I know there's all kinds of problems that I've been told as far as they exchange the child every day, basically. But there's all kinds of problems. Mom cites them, whatever. I guess we'll deal with everything in an evidentiary hearing. And that's what you asked for. That's what's said in the order, and I guess you're entitled to it. So we'll get an evidentiary hearing to find out what custody, parenting time, all that kind of stuff should be. Anything you wish to add, ma'am?
No, I just, the reason that I had filed that motion is because I was under the assumption that after the GAL had done her review of everything, that there'd be an evidentiary hearing set right away. And it's kind of stressful for the minor to have to go back and forth every other day, and it hasn't been working out like that because the plaintiff is very, very busy.
What you guys set up in the past. I was discussing with the way things were going, and I set that up. If you guys want to decide that she goes back and forth every other day, I don't care. Do you, would that be better or worse or what?
She wants it to be where she wants is here most of the time, and
well, that'll have to be determined through an evidentiary hearing. It was not something that was automatically going to be set up. As I say, my hope was that the GAL would get in this case and be able to reach some kind of a compromise, some kind of an agreement somewhere where we would not have to have an evidentiary hearing. But it clearly we are. You haven't been able to figure stuff out. You're asking for things. He's asking for things, and I can only have an evidentiary hearing to make a determination on that. So we'll have an evidentiary hearing, actually, on parenting time to make a determination. on that. And everybody, you'll get a scheduling order. You need to follow the scheduling order. All right, it'll call for trial briefs and exchange of witnesses and all this kind of stuff. You need to follow that, ma'am. I know Mr. Reams will, because he's done this many times. I don't know you will, but you better figure out how to do that, okay? Because it could end up, you won't be able to put in evidence if you don't follow it. I'm just
What am I supposed? I'm sorry. What am I supposed to do when she's here extra times and he's not home and says it's okay for her to be here, and so she's just here? I mean, am I going to get in trouble?
I'm going to set up an evidentiary hearing regarding parenting time. That's what the motion is, and that's what you'll get.
Okay.
All right. Mr. Reams, anything you want to add?
No, Your Honor.
Thank you. We'll get a date out to you as soon as possible.
Thank you, Your Honor.
Thank you. We're adjourned. Matter of Cervera versus Nickens. Miss Cervera is present via Zoom. Mr. Nickens is not present and has never been present by Zoom or in the courtroom. Our courtroom's open. He could show up too. This was his motion because he from a 10-3-23 UCSO that he's required to pay $13.25 for 2 children. He has employer wages at like $31, almost $32 an hour. He says he just can't afford to pay it and wants to pay only $7.50. He has not shown up for his motion. I have no reason to change the UCSO on this matter. Is there anything you want to say, ma'am? I'm going to.
Yeah. Yes. I just have a couple of questions. Right now, I'm kind of worried. This is just, it may be off the subject, but I'm kind of worried because he took my son Friday and he's a complex child and no response or anything. So that's the thing. If he's getting evicted and, going to be shortlisted.
I have nothing I can do about that at this time.
Yeah. And just wondering too, am I in full custody of both boys then?
You got whatever order you have here at this point. The order that you have gives you custody, I believe. But it's only on the basis that says the petitioner mother has initial custody without prejudice to determination of either parent's custodial rights. Either party can, and that's just from October of last year. If you read your order, it tells you have it, but you can actually ask for a judicial determination of it. But at this time, you have custody of the children.
Oh, okay. All right.
So I'm going to deny his motion to change child support, which is the only thing in front of me, basically as much as anything, because he didn't show up. But he really did not provide a reason other than he just says he can't afford it on it anyhow. So we'll issue an order that denies his motion regarding child support. All right. Good luck.
Okay. Thank you.
Mr. Donaldson is present with his attorney, Mr. Cox. This is Ms. Donaldson's objection to the ex parte order. I'm assuming it was the 1/4/24 ex parte order that grants exclusive use of the marital home to the defendant, grants him attorney's fees, and that the plaintiff basically is not permitted to be in the home without written permission from Mr. Donaldson. I've read your motion. What do you wish to add briefly to it?
Are you asking?
Yeah, it's
myself?
your motion. Yeah, it's your motion.
Oh,
are you still in the house?
I am currently in the home, me and the children. Yes, sir.
Even though the orders have told you to get out?
Well, that says if I do not have permission and I have permission to be in the home, I've spoken with Mr. Donaldson. Mr. Donaldson knows that I'm there. He has
written permission. Mr. Cox, does she have permission to be in the home?
She does not, Your Honor.
All right. Ms. Donaldson?
Yes, sir.
He says you don't have permission to be in there.
Your Honor, I actually do have permission. We have email communications back and forth. Mr. Donaldson knows that I'm in the home. We've been in communication with the realtor for the last couple of weeks. She also knows that I'm in the home. There has not been any expressed concerns about me being there. He did say that he was going to write something to allow me to be there. He has not provided that, but he has also not expressed at all any concerns. He comes back and forth to the home to bring the kids, and that's just how we have been we have been living in and living in the home.
What's your
I take the kids
motion
back
here
and forth
for?
to school for him every day.
You're trying to
He
set
drops
aside, you're trying to set aside this ex parte order that gives him exclusive use of the home?
Correct. He does not live in the home. He has his own separate home. He has moved out. And there's no reason to have that exclusive use. He filed a second ex parte without fulfilling the first one at all. He was in the home 60 days during the first ex parte, and he did nothing. So really, when you look at it, he had no grounds or a need to file the second one when he already had full access to the home and full authority to move about at his discretion. And so there has been no further disputes between us. He's left a home, and we've been both taking care of the kids, and he brings his son to me in the mornings because he doesn't have means to get them back and forth to school. That's the way that our kids get back and forth to school, and it's their foundational home as well. So it's just not in the best interest of the children, nor has it been a problem with me being there. And again, we have written communication back and forth that Mr. Donaldson does know that I am in the home. We do have emails to support that, sir.
Knows you're there. That doesn't mean he gave you permission, but I'll ask Mr. Cox. Mr. Cox, your response.
Your Honor, thank you. Your Honor, we've tried everything. We've tried ex parte orders. We've gone through.
I've had a hearing.
Certainly, you've had a hearing. The plaintiff has destroyed the garage door twice. She punches holes in the walls. This realtor I have is a very good people manager, and she's tried everything. We just can't get in. I've got an email from her today, very alarmed, saying that she's concerned that she's not able to sell this home, as it is nearly impossible to have showings. I have 4 showings set for Friday. Mrs. Donaldson said that she has left for a trip out of town and failed to put the key in the lockbox. Your Honor, it just goes on and on and on. I don't want to inundate you that with stuff, but the point is that she just will not allow us to get this house sold, either by destroying it or making it impossible to work with the realtor. The realtor just needs to be able to get this house sold, and we only can do that by having this ex parte order upheld. She has to be removed from the home. We've tried everything to try to get her out of the home, and she files these motions about how she was somehow wronged in the judgment of divorce. Just to kind of demonstrate how irrational this, Your Honor, we entered into an order before the judgment was entered that said, all right, so your 401k, Mr. Donaldson, is worth $103,000. But you, Mr. Donaldson, only have 14 days to tell us in writing what your premarital portion was. And he said it was somewhere between $30,000 or $35,000.
Oh, that 401k stuff supposedly held up the actual entry of the judgment. I don't care about that. It doesn't matter who did it. It only matters that I have in front of me a judgment of divorce that I am going to enforce the 4 corners of that, nothing outside of it. Okay. And that judgment of divorce was entered on August 25 of 2023, stating specifically the house shall be listed for sale immediately. There's no other way to put it other than it says immediately. We are now in February and it still isn't. I know that there have been ex parte orders. I know I had a hearing on it and said it's got to be done. It was objected to my order. The judge has found on more than one occasion that the house will be turned over to Mr. Donaldson because it can't seem to get sold in any other way. I know there are attorney's fees that are now due that are part of a lien on the house that you're supposed to take her portion of the house or her portion of the equity for some reason. I understand. Isn't that correct?
Yes, Your Honor.
Ma'am, I don't know what else to do. You're just not abiding by a court order. I mean, I think I should have the police go out and remove you. And a court officer should set all your stuff out on the front lawn.
Well, I don't know what that would do for our children that I take back and forth to school that he does not have means to do. Well, he should care about the welfare of his children.
I understand,
and he should know.
But I'm enforcing the order. The order. There's nothing.
Your Honor,
it doesn't.
Like you
say
said, it's been February. 4 months passed. He was in the house for 60 days and with an ex parte order in place the first time and did nothing. The house did not get on the market until January 30th, 2024. Those are not because of delays of myself.
It's
Your
because
court
you wouldn't
has
get out of the house
documented.
like you were ordered to. You've
No
been
one
ordered out of the
ordered me
house on
out of,
more
no
than
one
one
ordered me
occasion.
out of the home, Your Honor.
You've been ordered
We've been
out of the
communicating
house
with the
on more than
realtor.
one occasion.
No, sir. No,
Yes, you
sir.
have.
Mr. Donaldson has emailed me, and we have email documentation that Mr. Donaldson is fully aware and okay with me being in the home. He has worked with me, and we have worked together to say certain things about the home. But he knows and fully aware that I'm there in the home. We communicate about the children, so he has had no issue with me being in that home. These concerns are
We had
more
to
so
get
coming
you
from
out of the home.
he told me I would be allowed 30 days once the home is sold. The home has not been sold. It just got put on the market less than 2 weeks ago, Your Honor. And it's been over 4 months that they've had to do that with full authority to do it. That has not been on my delay because the court granted them full authority that they have failed to exercise in.
It took us a lot longer because we had to get a bunch of ex parte orders in order to get the realtor to get anything done. And it's
That's
just
not true.
impossible, Your
You
Honor.
had your order from September 26th, and he did not move out until December 1st.
What are you seeking today? Because, ma'am, this is the same thing that's been litigated that I started back in, I think it was.
Because it should have never been able to been filed in the first place, and it also should have never been granted because it had no grounds or no
I'm
means
sorry,
to
but I
file them.
granted it, then the judge upheld it, the judge did something else to uphold it, and again, and I'm upholding it again. It's a court order. You just don't seem to agree that the court order should be issued because you don't think it should. I'm enforcing a judgment that you signed. You signed it. You agreed to it. At that time, on August 24, you agreed to it. And you agreed to the fact that the house would be immediately listed for sale, and it didn't. All right.
That's not just on me. That's on the defendant as well.
There is nothing that I can get done, according to Mr. Cox. The realtor is saying I can't even do 4 showings today. Is that
That's
what
not true, Your Honor? They're having excuses after excuses when they've had multiple.
No, you've had excuses after excuses why you do not follow the court order.
They did not enforce the court order. They did not. Mr. Donaldson did not tell me.
Then that's what we should do. I should order the police to go out and remove you because then they will follow the court order. Okay. They want you removed from the home. And if that's what you're asking for, just
no, that's not why I would not want to put my children in that position. I would not ask for that. And I don't think Mr. Donaldson would be asking to put his children in that position.
He's running out of
He has children. So even whatever his personal things are, it's not in the best interest of the children.
This
is also a family related issue.
Today.
I'm asking that she be removed from the home today. We've got to try to get these 4 showings in. And I'm not trying to add more fuel.
The showings are already scheduled. They're already scheduled. I've been in communication with the realtor.
I just asked Mr. Cox, ma'am. Silence. I'm going to mute you. Mr. Cox.
Your Honor, one of my obligations under the judgment is the child has a disability that provides him with a trust that provides income to the child of $3,600 a month. I haven't even been able to deal with that with the probate judge as Judge Hillary ordered me to. And she is simply collecting the child's money every month, not working and obstructing the sale of this house. Your Honor, we're at a desperate need here.
What does that have to do with this order while we're here today? First, you're bringing up
and you're bringing up everything under the sun, and that is inappropriate.
Related
it has
to
nothing to do with it. It is enforcing a court order. Enforcing a court order, and you're supposed to be out of there. And that
court order also enforced him to do things that he has not done either. That the court has just put a blind eye to. He's supposed to pay the portion of my car. He has not done that.
And that isn't what we're here for. Stop.
It's a court order.
Just mute her. Mr. Cox, I muted her because this is just going nowhere. And it's hit my office and Judge Hillary's office over and over. We've done everything to try and be reasonable, and she just won't do it. Now, I don't know that Mr. Donaldson wants her put out in the street today. I don't know. I'm assuming you're asking for costs for this motion now too.
We are, and it's horrible to say that. I mean, he doesn't want her put on the street, but he knows that we just have no choice. We can't get this house sold. She's going to stop everything that we try to get it sold.
Can you check with your realtor and see today if she can at least get 4 showings in today? Does she have the ability to do that?
We don't have the key to the house to get in the house.
There's no key to the house because Mrs. Donaldson won't give it to her. She said she went on a trip and can't give her the key today, so the 4 showings wouldn't happen.
All right, well, this is her motion to object to the ex parte order. I find her motion to be frivolous. It's the same thing that I have done and Judge Hillary has done on this case since this started. And I think the first hearing was probably back in September 21st. I think at that point her counsel was also there, and there were attempts to do, change things. I don't think an order actually got entered, written order, because of objections and stuff until November. On this matter, there's been an ex parte order for exclusive use and possession, attorney's fees. Plaintiff is not permitted in the house without written permission. Mr. Donaldson, I want you to raise your right hand. That would be your other right hand. You solemnly swear or affirm testimony given in this case to be the truth, whole truth, and nothing but the truth.
Yes, sir.
All right, put your hand down. Have you given her permission to reside there for some period of time?
Yes, until the house sold. Yes, I did allow. I was giving her permission to stay in there, but with all these back and
How
forth,
recently did you give her that permission?
it was a couple of weeks ago.
And I mean, if you've given her permission to stay there, you're giving her permission to stay there. How long?
Well, until the house sold. Until the house sold. But it's like she's blocking from the house to get sold. So I have no choice but to say, hey, she got.
Are you revoking your permission then?
Yes.
As of today?
Yes.
All right. Mr. Cox?
If there's any hope that we believe she could demonstrate a single shred of cooperation with the realtor, but she can't. It's impossible.
I know, but right now I'm saying he is entitled to it, but he let her stay there. All right. He just told me, and I believe him because he's under oath and everything. He said he gave permission, but he's revoking it as of today. And that should be put in writing to her from him. And then, I mean, she's learning of it today. Ma'am, I'm probably going to give you like a week to move out because he's revoking his permission today, unless he gives you other written permission.
Can she be ordered to cooperate with the showings, Your Honor?
Yes.
All right, thank you.
Yes. Ma'am, you're muted. I can't hear you. I'll unmute you in a minute, but you cannot stop talking when I'm talking or anything, even when I'm doing that. You are ordered to cooperate with the showings that are scheduled for today. You said that they were scheduled. You are ordered to do that. You are ordered to get the keys or availability for those showings today and any other showings that this realtor schedules. You'll give her whatever is necessary to get in and do the appropriate showings. You will not in any way cause damage or something to the house to make it less saleable. I'm denying your motion today regarding your objection to the ex parte order that remains in effect. And as I say, I will give you 7 days to get out of the house unless something else is brought up by Mr. Donaldson and he agrees to some other time or something like that. Mr. Donaldson, I got to tell you this, you can't come in and ask that she be removed and then at the same time give her permission. You either give her permission and you work with her or you don't. And if she doesn't do it, I'm giving 7 days for her to be removed because you've revoked your permission at this point. Anything else, Mr. Cox? I'm going to, Miss Donaldson, you can unmute and state what you want to. You have to unmute yourself now. We've got it.
All right. Are you able to hear me now?
Yes, ma'am.
I have already been in communication with the realtor. I am not just out of town. I have a sick father, much like the defendant, and I'm out of town. I'm in Cincinnati, and I'm here visiting him. He may not have much longer to be here, so I'm just here seeing him, and and Mr. Donaldson knows that. But I've already spoken and communicated with the realtor in reference to that. The showings that were scheduled for today have already been rescheduled and confirmed for Monday. We've already talked about that and talked through that with the realtor. She is aware of that, and I am also aware. And I did apologize for my error on this one time that did for this particular time. I have offered also to repair the home on more than one occasion. That information is there. I haven't been the one to I've been the one trying to get the home repaired, because we can make a lot more money than what's being offered on the home currently. And so I've been trying to work with both Mr. Donaldson and the realtor to at least allow those negotiations to be made, because those are one of the main concerns that a few sellers have. The house is currently on the market. They do have all the photos that were needed that came in. They came into the home. We got it on the market. We just had an open house Sunday, February 1st. So I have been in cooperation. There were 22 people that came through the home, and there were communications after the home. So there has been steps that has been taken that I have cooperated with. They've gotten in the home. I've made sure to keep the home in decent condition and to make sure that it was presentable for the guests. I am hopeful that Mr. Donaldson will allow for us, I say us because it's me and his children that he would be putting out on the street, not just myself, because this affects the whole family. And I pray that he does give us permission to stay in our home, because it is still our home. I handled all of our affairs for the first 13 years of our relationship, all of our business affairs and personal. And so Mr. Donaldson, he's not a big negotiator. And so he expresses to me that most of what is being done with the home is being told to him what he's doing. He's not really saying it. He's never really been that person to take the lead in that. That has always been me. So I have been trying to be at the table to negotiate the best rates for both him and I, and also give options for these people that are going to buy it, because we can make more money. We can make up to $50,000 more money that his realtor has said that we could make. And I'm trying to be able to do that. So we can both put more money in our pockets for ourselves and our children that we both need.
The house must
But I will be in
immediately be
cooperation.
sold. And it must be, it doesn't say anything in the judgment about repairs or anything. It must immediately be sold.
Yeah,
If
it wouldn't
you are
stop
going
the
to, if
selling
you are going to
or
talk
delay
to
it.
Mr. Donaldson about something, you're not being prohibited from talking to him or something, but you are prohibited from interfering with the immediate sale of the house. Okay, you can't hold it up because I want to repair the living room.
It wouldn't
that
hold
kind of
anything
stuff.
up. It wouldn't hold it up.
Yes, it would. You got to
do it
fix
before
it.
the
So don't
closing.
give me
The
that.
same thing that we've done when we
Ma'am,
purchased the house.
ma'am.
Yeah, same. But go ahead.
Well, thank you.
Honorable.
I'm
So
just
go ahead.
telling you that it will hold it up. I know what it does to fix a house. It holds it up. You got to do the
It's mine. I already had someone come in and give estimates, but okay. All right.
Jesus. That's going to be the order of the court. She will fully cooperate. Obviously, if she doesn't cooperate with the Monday showings, you can come back and get an immediate order to have her removed. All right. I know you've got them before, but with whatever, because she said she's got it all set for Monday and everything is set up. Okay. And that's her own words to me right here. And if she violates that, I'll use that against her too. Unless you agree, she's to be out next Friday. I will reserve costs for Mr. Cox. You can you'll be able to bill for your time, the amounts and stuff like that. I'll reserve them for right now for this hearing, only because unless stuff goes the way it doesn't seem to be going, there'll be more. And I will grant costs to you at that time, Mr. Cox. That's going to be the order. If Mr. Donaldson and Miss Donaldson want to cooperate and give more time or do whatever, that's fine. But you're here telling me, Mr. Cox, that he wants this done now, doesn't want to make repairs, basically, just wants it done, just sold. Just sold. Is that correct?
Yes, Your Honor, we're just trying
I
to
understand.
allow our realtor to do her job, and Mrs. Donaldson is not allowed to do it thus far. So,
And if the realtor comes in, ma'am, and says you're putting anything in her way, I'll have the police come and remove you. I'm tired. I'm done. So that'll be the order of the court. Anything?
thank you.
All right, thank you.
Have a good
You'll
weekend.
draft the order, Mr. Cox.
Yes, Your Honor, thank you. Have a good weekend.
You too, thanks.
I'm just gonna say, I was gonna vote, I was here.
I'm gonna just dump them all out. Somebody has an excuse for everything. Everything. ES, Armator versus Jacobs. We have both parties present as well as their respective attorneys. I don't think I have necessarily appearances from people, but I trust that you will file them appropriately. Mr. Hilderly is here for Mr. Jacobs. Ms. Krondyke is here for Ms. Parmenter. This is the time set for the father filed an objection to a friend of the court report and recommendation regarding everything: physical custody, legal custody, parenting time, and child support. Had I known there were two attorneys, I would have called you ahead of time and said, I have nothing else that I can do except set it up for an evidentiary hearing. There are objections that were filed, and as such, I got to set it for an evidentiary hearing.
Your Honor, if I may, neither my office nor my client was ever served a copy of the objection. So that's why we had no idea. The only reason we knew to be here today was because we looked on her case to see if the recommendation was signed, and we saw this notice. So I don't know where he sent it, and I didn't know there was another attorney on the other side. I just want to make that clear that we haven't gotten a copy of the objection. So if an opposing counsel can send that to my office, that'd be wonderful.
Mr. Hilderly, do you have a copy of the objection?
I do, Your Honor, and I apologize. We did send an appearance out. It probably hasn't made it to the file yet. Originally, they told us that this was needed to be adjourned today, so that was the reason it didn't get sent out. My client did email it to the plaintiff, but I will make sure that it is sent to Ms. Korndike so that she has that, and then she also would then have my info as well.
Yeah, as I say, normally if I know there's two attorneys, I call them and say I can't do anything other than have an evidentiary hearing, and you wouldn't have to appear today. But I didn't know either of you were on it until, lo and behold, you showed up here today. Nice seeing you, but it's too bad that you had to do that. Mr. Hilderly will make sure, ma'am, Ms. Korndike, that you do get a copy of that, as well as a copy of his appearance. If you could send him a copy of your appearance and anything that is necessary, I hope the two of you can, number one, maybe even sit down and negotiate some of this with the help of the report and recommendation. But if you can't, we'll be setting up an evidentiary hearing. We'll contact both of your offices, and my clerk will try and schedule it within your schedules. All right. But if there's too many, if she can never find something, she's always been instructed to try about twice and then just set it. Okay. So please work with Miss Dewey when she gives you a call. All right. She's actually a lot nicer than I am, so I think you'll be happy to work with her. Okay. Any questions?
No.
Thank you again. Like I said, too bad you had to appear, but we'll get through this. Good luck, everyone. Thank you. We're adjourned.
Thank you.
9 DM. Both parties are present via Zoom. This is the defendant's father's motion for custody. The original custody order was from a judgment of divorce, gave her sole legal and physical. Since that time, there have been numerous motions, ex parte requests, things back and forth between the parties. Apparently, mother still has custody. Mr. Lindsay has submitted some documents that indicate that the children are living in a completely inappropriate location. CPS has been contacted. CPS worker is in the waiting room, but I've not brought her in because this is not a hearing per se, not an evidentiary hearing, but if necessary, I'll bring her in and ask her questions. The father has sent in pictures of the housing, has made numerous statements about about Peyton, the oldest child, calling him and asking him to come pick her up because of the things that were going on there. I believe there's also some stuff that where she was living, the person who owns the property. I don't know that she can continue to go back there. And he is asking for a change of custody based on that. Based on his statements, I'm quite convinced that there is proper cause and change of circumstance to allow for an evidentiary hearing. I cannot change custody here on a Friday morning, but we'll continue on in a moment after I have an opportunity. Mr. Lindsay, is that about sums it up basically?
Yes, sir.
All right, Miss Lindsay, what's your response?
As to the details that he shared, they were taken out of context, and it wasn't as it was that we stayed in the home, and the travel trailer was intended to be like as an additional living space for the girls to be able to hang out without having my friends or former friends, kids in the midst of it all, so they wouldn't necessarily butt heads. And I was also told I would be connected to electricity as well as water. And when it got up there and everything was situated, it wasn't that way. And her and I were very, very close friends, but over the course of time, things just became more and more tense, and it just wasn't panning out to be a beneficial situation, which I was already starting to look into other alternatives to housing to stay, which I've already moved and staying in Granville, and the girls would each have their own bedrooms.
And you're paying rent there or what?
Yes.
Is it a house? Where are you living?
It's with my grandmother. She has a 4-bedroom home in Granville.
Why weren't you there before that when you were living in the camper with no running water and electricity?
That wasn't living in the camper with no running water or electricity. That was just our additional space. But
You said it was additional, but I can read between the lines that there was an awful lot of time because she was supposed to connect it to there and this and that, and it is not. And I do have CPS out there. I do have CPS at least attached as a document, a safety plan that they recommend that the children not go back to you, and that there should be a custody hearing on it.
although there's been no one's ever met with me. No CPS never came out to that property. That CPS worker that had written up the safety plan is Kevin's ongoing CPS worker from the incident that he had occur in October.
So even if it is an ongoing from an incident and stuff like that, the CPS worker did say there's a safety plan signed by everybody. Keep children safe, not return them to Michelle mom due to concerns of physical abuse, substance use, allowing Peyton to use substances with her. Those sort of things. I can't overlook those at this point. So let me tell you this. There's clearly proper cause or change of circumstance to have an evidentiary hearing regarding custody. I've already explained, I cannot change custody on a Friday morning. I have to have an evidentiary hearing. You both be informed of the evidentiary hearing. If you know what you're doing, you're going to hire an attorney because you don't know what you're doing in a hearing. When you come in here, it's a formal hearing. Evidence, it has to be admitted in an appropriate way. It's not just sitting there talking. It's calling witnesses. Evidence has to be exchanged ahead of time. Anything that somebody wants to put in has to go to the other party ahead of time and all that kind of stuff.
On that note, sir, could we make sure that the defendant is advised to actually send it to the correct address? Because I never received any motion in the mail at all.
You just moved.
True, but he didn't send it to the address that what I have on file with front of the court at the time. He sent it to the address that's in Pearson, and I was never allowed to use that address.
So what address do you think you were supposed to send it to?
From my understanding, he should have sent it to the address I had on file at the front of the court, which is 607.
But you're not there.
True, but I have a change of address put in, and I have recently changed my address with front of the court to 3.
Well, you're here today. You must have found out somehow.
I was able to get a copy from the court clerk.
Where were you? Was the place up in Pearson? Is that the address that you were at with the kids? Is that
Yes.
the camper address?
That's the home address. But yes,
It seems to me like he knows that that's where you were living and that's where the kids were living. And that's where he came and got him. So I mean,
he also knows I wasn't going to be
I don't
staying
really-
there.
What?
He was also informed I wouldn't be there anymore.
He picked up the kids from there. Did you inform him then, right afterwards that you moved? Or an address?
No, not as of yet, because he's not the most easy person to communicate with on occasions.
Doesn't matter. I'm just telling you, if he went there and picked up the kids and the kids know that's where they were living. And I'm sure, I mean, they're 13 and 10 or something like that. That's where they were living. That's where I would think he would send it, because if he sent it to some other address, you'd say, I wasn't living there. And he knows I wasn't living there because that's where he picked up the kids from. It just doesn't make sense to me that you're asking that he sends it to someplace else that he knows you don't live. And then he'd come in here, and if you didn't show up, and I'd say, where'd you send it? And he'd say, I send it to an address, but I know she doesn't live there.
He also knew I wasn't going to be at that address anymore past that day that he picked the girls up.
I'm not sure. I don't know if he knew that or not. But even if he thought you were going to move from there, you should have contacted him and said, this is my new address. I mean, there's got to be some responsibility. Otherwise, otherwise you'll come in and you'll say, I didn't get it because he knows I moved from Pearson. So no, I think he did what he could at that time. I think everything has occurred appropriately as it is. I'm going to allow for an evidentiary hearing. I'm just telling both of you that if one of you gets an attorney and the other, you're going to be in a huge disadvantage. And if this is really important to you, then I suggest that you seek out a family court attorney. It's not cheap, but this is your kids' lives that you're fighting for, according to the two of you. Then we'll set up that evidentiary hearing. The question will be is, where should the children live in the meantime? And I think that from what I saw, that they were in imminent danger when they were up there in Pearson. I'm sorry, but I don't. There's nothing about that seemed like it was appropriate, and that they were in imminent danger. However, Mr. Lindsay, if she visits the kids at her is it your mother or your grandmother's house, ma'am?
My grandmother.
Do you know the grandmother, sir?
Yes, sir.
Can the kids visit her there?
I don't see why not, sir, but from my understanding, she hasn't called to check on the girls one time, sir.
You don't.
And she hasn't reached that. CPS has reached out from her from the number that I contact her on, and that's why she hasn't answered to them. That's why she hasn't talked to CPS. So I'd like to get her drug tested for one.
I would happily comply with that. Happily, and I have a time set up with a courtesy worker from Kent County next week.
What I'm trying to do at this point is I'm going to leave. Where are the kids attending school, sir?
The Chesaning schools out here at my house. They're attending the middle school and Big Rock Elementary.
Okay, so they're enrolled in, what is it?
Chesaning.
Chesaning?
Saginaw County. It's in Saginaw County.
Yeah, I know where Chesaning is. It's not too far out. I used to drive through it all the time, going over to Frankenmuth from here. So I think the kids can remain and they are enrolled there now. They were not, I take it, when they were with mom. They were enrolled.
They were enrolled in school.
Yeah, I'm just saying they weren't enrolled in Chesaning.
No.
All right. I'm not gonna keep these kids around. They're gonna stay at the Chesaning school. I'm gonna allow you, ma'am, to visit with the kids, have parenting time every other weekend until we can get to a hearing date. Because it's going to be a little while till we get an evidentiary hearing on it. Parenting time that you have must take place at your grandmother's house. All right. I feel fairly certain that that's safe. Even I know there are allegations of drugs and stuff like that. I can't imagine that your grandmother allows you to sit around and do drugs. Okay. I know you're going to deny it. So I know you're going to deny it. I'm not saying anything. Okay. We will leave it so that So you can have every other weekend. You can, sir, do the girls have like a phone or something she can call them at, or?
Peyton has a phone only when there's Wi-Fi. I have my phone.
Her
We have a
microphone
house,
doesn't work.
we have a house phone.
Oh, you do have a house phone?
Yes, sir.
Does she know the number of it?
No, because she hasn't reached out at all since I picked the girls out, except a text that telling Madeline happy birthday. Other than that, she hasn't talked out to me at all.
You haven't made it a welcoming like I could. You've outright told me just basically leave
I'm
it
setting
alone.
this
I said
stuff up.
nothing to you.
Hold on, stop both of you. I'm just setting this stuff up. Ma'am, you can have every other weekend starting next weekend. Friday at 5 o'clock till Sunday at 5 o'clock. Exchanges, you're over in Chesaning, sir, and she's here. We gotta find a place to exchange the kids, somewhere between.
We had a previous meeting spot for my every other weekend, sir, in Muir.
And that's kind of between the two, isn't it?
Yes, sir. It's almost exactly halfway for both of us.
And what was the meeting spot? I mean,
It was a gas station.
are you
It was a
familiar
gas.
with? Are you familiar with it, ma'am?
Yes.
All right, then you'll meet there. The parties are to not cause any problems there. I'm assuming that the gas station probably even has a camera and stuff like that.
And what if she doesn't return the girls on that time, sir?
I don't do you.
Hold
I
on.
wouldn't do that.
Ma'am, trust me, it won't go good for her. You will probably, I can't give you a lot of advice because I got to sit and be neutral. Okay. I can't help you and I can't help her. If she doesn't return the kids, I'm sure, number one, there are attorneys who can help you to do that by an ex parte order or something like that for return of the children, whatnot. I'm hopeful that that does not occur because it certainly does not help her case when we get to the custody hearing. All right.
All right.
And it doesn't help you if you don't get the kids there. Okay. I mean, if you don't get them there on Friday at 5 o'clock, it doesn't help you. At some point, that my only real concern in this is the kids. All right. It isn't mom, it isn't dad. It's the kids. And I'm going to try and do something that is appropriate for the kids. And I think they should see mom. I think there's enough imminent danger that I'm not willing at this point to return the custody to the kids, but we will have a full-fledged hearing whenever that hearing comes up. But I'm telling you, there, when you get the notice, you got to read the whole doggone notice because it will tell you stuff that you got to do on there. Attorneys know it, but you don't. All right. So you got to read that stuff. We'll leave the kids enrolled in the Chesaning school until further notice so that they are not interrupted again. They've been in the Pearson schools and now Chesaning, and I don't want to now move them to Granville. Their education is going to suffer. In the meantime, both of you think about the kids first. Anything else? I do have proper cause change of circumstance. Do have an evidentiary hearing. We'll set it up as soon as possible. Anything else? Friday at 5 o'clock to Sunday at 5 o'clock starting. Would you just starting next week? I don't know how to get a phone number for her to contact the kids at because we're on YouTube and I don't want you to yell out a phone number so that anybody who's listening to it gets your phone number. Is there a way to email it or anything to her so that she can have a phone number to contact the kids at?
I can text it to her. She texted Maddie happy birthday and I got that. So I can text her.
You are responsible to text it to her by noon today. Okay.
Yes, sir.
Ma'am, you can, I mean, that doesn't mean you can call the kids every 10 minutes, but I'll give you, I mean, you also can talk. These are not little tiny kids. They're 13 and 10. I mean, you can call and talk to them. Just can't be unreasonable. You understand that, don't you, sir?
Yes, sir.
All right. We'll see you all. We'll send out the order. The reason I'm waiting until next week is because you won't get the order probably until sometime next week. You're due, and that's the exchanges in Muir. Is there a name of that gas station, or you guys know where it is? So I'm just gonna.
It's a Marathon.
I can't imagine that there's more than one Marathon station in Muir. So at the Marathon station in Muir, let's get that done. All right, anything else, Mr. Lindsay?
No, I don't believe so, sir.
Thank you. Anything else, Miss Lindsay?
No.
Thank you all very much. We'll see you in the near future. Good luck.
Thank you, sir.
Oh, that's 10:30. They never log back in? Oh. Pete, you're on it because I forgot all about this.
I would have.
Welcome back.
Good morning, Your Honor.
Good morning. We have, ma'am, can you hear me?
Yes,
All right, Miss Davis. Earlier, it seemed like Mr. Samuels was with you. Is that correct?
yes, and I think he was gonna try to join now as well.
iPhones.
Got a ton of iPhones have just started to log in. Brian, are you Brian Samuels?
I am Brian Samuels, yes.
All right, here we go. Maybe back to your case. You guys were on earlier and we brought in Miss Smith Lowe and then you were gone. And I understand you had to take kids to school. She got a message and we've done everything to try and fix this up. It is Davis versus Samuels. We have both parties present as well as Michelle Smith Lowe from the prosecutor's office. I think this is regarding Lewis, I believe is the child's name. Miss Smith Lowe is seeking to enter a judgment of paternity, as well as a UCSO or a child support order. There was no DNA requested in this case, as Mr. Samuels says that he is the father of Lewis. Calculations were made, and I've been told there are some things that are unusual here. There's deviation because you got kids, some ordered out in Ottawa County. I'm going to let Ms. Smith Lowe explain this to me.
Thank you, Your Honor. As the court is aware, this case was filed on or about September 12, 2023. Mr. Samuels was served and responded, not requesting genetic testing. Pre-hearing conference was scheduled originally on November 8th, 2023. And we made a number of attempts to meet and discuss it. I think all of our schedules were complicated. And ultimately we met on December 20th, 2023. The calculations were changed to increase Miss Davis's income to be a little more fair and equitable. She has income from 3 different restaurants that food establishments that she works at. And so the new calculation puts a total support of $1,546, but parties agreed to deviate to $969 to give Miss Davis $300 per child. Mr. Samuels is already paying $600 for 2 children in Ottawa County, and to keep those orders from not being disturbed, we backed those numbers out of this calculation. She is not receiving food assistance, only Medicaid. So the deviation for base support went to $670 from $1,247. Ordinary medical is $69. Child care is $230. And the total, the recommended total was $1,546 and it went to $969. Once the $600 deviation is subtracted from the $969 base support of $613 that is ordered in.
Is that in Ottawa County?
Yes, that is in Ottawa County. For the 2 children in Ottawa County, it would have Mr. Samuels paying $356 in Kent County. Medicaid is the only state assistance. We would ask that the judgment, and actually these documents, the parties consented and agreed to this, and documents were sent to the parties to sign via DocuSign, but those weren't signed, so this was scheduled for a hearing.
Okay, so the deviation occurs from basically 3 children, 2 of which are on Ottawa County's calendar, and 1 of which is on ours. The deviation occurs because it would be $1,546 for all 3 children that you would calculate. But you've taken into account Ottawa County's, like $600 that he owes for the two kids.
Correct, $613 for the two children
And then made it so that it was 356 here.
here in Kent County,
Yeah,
yes,
so it's like, he pays like $970 or something like that total.
yes.
Okay. Ms. Davis, is there anything you want to say? You agree to all of this, the deviations and everything?
Yeah, but then in the meantime, Brian lost his job, so he's laid off. So I think we have to kind of refigure, but he doesn't have a new job yet, so.
Right, been working on it.
Are you having any luck?
Well, I finally actually went to Indeed a couple days ago, and I'm getting a lot of bites on there. But I still work at I bartend at 20 Monroe downtown, the venue. But I told me, like since this year started, I've had 2 different events that I worked, so I've made less than $100 there so far. But I'm looking into getting on the production side there, and like I said, Indeed's been emailing me a bunch this week with job opportunities that I'm looking at. So,
all right.
Your Honor, this effective date was originally set for October 1st of 2023. I don't know if the court wants to consider or have Ms. Davis consider a later effective date. This case is scheduled, or if you want us to adjourn this, we have until early May to complete this case.
Well,
sorry.
No, that's
right.
I know you would like it adjourned, sir. So I think, okay. But I'm gonna ask Ms. Davis, do you want it adjourned? Do you want us to, I mean, I would, if I do enter it, I would probably start it as of February 1, as opposed to going way back to October or something like that. That would give him a considerable break. Ma'am, what is your thoughts on this? You guys are working together, so I'm gonna let you.
I mean, I feel like Brian's probably gonna have a job before May. So, but I do think it's probably fair to give him some time to find a job. So I don't know.
You want to set it for mid-March?
Yeah, that sounds good.
Let me adjourn it to sometime in mid-March. I know I'm going on the 6th or the 8th. So either the
March, Your Honor, your calendar for March would be
22nd or the 1st. No, not the 1st. 22nd.
March 22nd.
I'll probably have 1,000 of them because I'm not gonna have any on the 8th. Okay, so my suggestion would be, why don't we do it on April 5? So that because I think I'm gonna have a lot, because I'm not gonna do any the week before. So
that's okay, that's fine. Yeah.
Why don't we set this for April 5? We'll get this taken care of. In the meantime, sir, continue to give her support. Okay, she's got
absolutely.
And because the two of you are working together, which is such a wonderful thing today to hear that. You're the first group that everybody's gotten along.
This is that nice.
So thank you.
You're welcome.
Your Honor, may I confirm with the parties that their addresses haven't changed?
Yeah,
they have not. Mine has not changed.
And I'm not going to read the address fully because we're on YouTube. But ma'am, yours is 527.
Correct. Yep.
And sir, yours is 1916.
Correct.
All right. We get out appropriately. Thank you, Ms. Smith-Lowe, for.
We'll notice that for April 5th.
Thank you very much. Take care, everyone. Have a good day.
Yeah, you too. Thank you.
Thank you.
Goodbye.
Put them all on there.
96DS. We have both parties present via Zoom, and Ms. Mobilia, who represents Mr. Borakawa. This is the plaintiff's motion for a tax exemption. She says the dad claimed the tax exemption for the two kids. How many kids are there that we got here?
There's 3.
There's 3.
Yeah.
Says dad claimed them for 20 and 21. She claimed them for 22. She wants to claim them because, number one, are there 3 minor children, or is one of them an adult?
One of them just turned 19.
Well, that's an adult.
Yeah, so she still counts as a child.
I beg your pardon?
She still counts as somebody I could claim.
Well, that's fine. You can claim, but she's not an adult, or she's now an adult.
Yeah.
She wants to claim all these kids on her 2023 partly because dad didn't buy the oldest child, didn't take part in buying a car, and she wants to catch up on her debts. As I went through the file, there is nothing, Miss Mobilia, that I know of in the file that talks about tax exemption. Is that correct?
I didn't see anything around it, correct.
All right. There's nothing in there about it. So, ma'am, you can make a brief statement if you want, but
Yeah,
brief.
me and Brian have always talked about or came to an agreement. That's why we've never really had any arguments about any tax exemption. This has always been talked about. We communicate about it, and then we move forward with it. So he did know. Him filing, he had to help me out because he claims one child that he really doesn't take care of. He knew he had to always help me out with the money so I can pay my taxes or get her a vehicle. Not necessarily he needs to be the one to get her the vehicle.
Well, let me tell you that you can tell me that you guys agreed, but obviously there is no agreement on this.
No, it's not. No, there is no agreement.
All right, Ms. Mobilia, any brief statements? Quite frankly, I mean, you filed a response.
I did file a response, Ron. My client's not obligated to, assist an adult child. I assume the adult child may work and need to claim her own exemption. My client's not obligated to help her with any financial issues that she may have. My client has the children the majority of the time, which is indicated in her response. The reason that the motion was filed is because they couldn't agree, and Ms. Thompson would just take the children. My client provides for all their needs, all their educational needs, all their medical needs, takes small appointments. And so at this time, Your Honor, that to the IRS code, we're asking for.
Right. What you're asking for, in essence, is that the IRS code, the regulations will determine who gets the. And ma'am, I can't think of any reason why I shouldn't. There's nothing that is in any agreements anywhere. There's nothing. If he qualifies under the IRS regulations, and it sounds like he does for the for claiming him, I don't know if he can claim all three under the or not, but he can certainly claim the ones that he gets under the IRS code. I don't know if a 19-year-old he'd meet that or not. I'm kind of getting the idea that he might not, but the minor children he has the majority of the time, and the IRS code will give that to him. I'm not going to change that in any way. I'm just going to let the IRS code take care of it.
I'll prepare the order.
All right. Thank you both. We're adjourned.
Thank you, Your Honor.
Ms. Pintarelli, can you hear me? Huh?
She sent me a message that it's showing her on her end that the host will not let you unmute yourself. Can Mr. May unmute?
Mr. May, can you unmute?
Yep.
All right.
Why she's getting.
She's connected right now and says she's muted. Miss Pintarelli, are you saying that you cannot unmute yourself? Well, how can she answer that?
She can't. She emailed me, but
She can message you in chat.
She has messaged my clerk.
she sent me with a picture of her screen that says that I won't let her unmute, but everybody else can. I can't just pick her that she can't unmute. So let's get
What if she?
phone number to call.
What if she logs off and comes back in? Oh.
When she logged back in, she wasn't on mute. It was.
No, when she just connected right now, she connected, but it went automatically to mute. And she is sending a screen saying that the host will not let her unmute.
Oh.
Shows on the screen. However, I've never had that. We mute people, but they can unmute.
Yeah, it's got to be something on her end. I don't know what to tell her to do.
Yeah, I'm not sure if it's in the settings or anything.
Yeah, the right-hand corner gives her the option to, of her
Yeah.
screen, gives her options to select.
And I understand that she does that, but she just sent my clerk a picture of the screen
Right.
that says right on there, supposedly that the host will not let her unmute. And we are not. We haven't done anything. I mean, we just muted somebody earlier that didn't want to be muted, and then when I was done I just said unmute yourself and they unmuted. And that would have been somebody I would have kept muted forever. But they can unmute. And I don't know why she can't. May versus Pintarelli. Mr. May is present via Zoom, audio and video. Ms. Pintarelli has had problems, so we have allowed her to call in, and she is present on phone. This is a motion made by Mr. May. We've recently had a custody hearing, parenting time hearing, and set up certain times. He says that mother has again violated it and not returned. I think it's on. Is it only Isabel, Mr. May?
Correct. Yep.
Right, and is supposed to return her on Sunday and didn't. Mr. May, when did she come back?
Unfortunately, it was the following day, but I had to utilize the school's help to sneak and get Isabel back from Shauna.
Did she return Isabel to school?
No, she went to actually go and try to pick up Darian from school. So the school notified me to the middle school. So the school notified me that mother was en route. And so I explained the situation that she had not returned Isabel. And then they tried to occupy Miss Pintarelli. So they refused to let Darian go with Miss Pintarelli so she could stay there. And I was able to unify or get Isabel out the truck that she kept her in while she was in there visiting with Darian. And so when I got Isabel out, she got out crying and kept saying, "Dad, I tried calling you, Mommy wouldn't let me call you."
Right.
Yeah.
That's fine. All right. So this was this 2 weeks ago? Sunday, Monday?
Monday, yes, it was Monday afternoon when I
Did you
was able
file
to
a
get it.
complaint with a friend of the court?
I have, along with the other ones, and I haven't heard anything back yet.
All right, Miss Pintarelli, what have you got to say? Ma'am?
Nothing.
So
He says he showed up at 7. The order says 7:30. I showed up at 7:30. He wasn't there. I brought her up there on my own time. I had things to do.
You guys are supposed to exchange at what time?
7.
Didn't. I can go and find out in the order.
Yeah.
You were there at 7, sir?
Yep, 7 to 7:30. It's been like that for a couple years now.
Ma'am, I do have to say that when you were leaving here after my ruling, you indicated that off the record that you probably weren't going to abide by the order that I was doing anyhow. To return the child. You didn't bring her back for school on Monday morning?
I did.
The correct time?
No, she was sleeping.
She was sleeping.
No, anyways, I don't remember.
All right.
I don't remember. But she did end up going up there.
You didn't have her to school on time. All right. In fact, you didn't have her to the return period on time. And didn't return her. This has been like
I did return her on time.
Sunday night?
Yeah, Mr. May wasn't there.
What time did you have her there?
30.
What?
7:30.
That was at the gas station. Don't you guys exchange at a gas station somewhere?
Correct. I've got pictures, Your Honor, of me leaving. It was like 7:32 or 7:33. I take pictures when I arrive there, and then I take pictures when I leave.
What time did you arrive? Just so.
To be exact, it was 7:04.
Okay, and it's your understanding at 7 o'clock is the exchange. Well, all right. Ms. Pintarelli, you've developed a consistent abuse of the court order. I think it's been at least, I know Mr. Pintarelli or Mr. May sought an ex parte because you didn't return the child, in December or something like that. It was November or December.
So what are you going to do there for me being there on time? This is bull crap.
All right.
It clearly states I didn't drop her off at 7. The order says 7:30. No, I'm sick of Mr. May's bullshit.
I'm suspending parenting time. You'll be allowed 2 hours at Journeys each week. You can sign up for it. We'll send it to you. Thank you.
Whatever.
Yeah.
Is it part of firing me?
Mr. May, you understand? You will be responsible when you get the order to contact Journeys to make the kids available. Ms. Pintarelli, you'll be responsible also. That'll be set up through there. Thank you.
Thank you, Your Honor.
Thank you. We're adjourned.
I'm okay. I was just in the process of emailing Tracy asking where we were in the pecking order.
Well, we're getting, the last one, we had a lot of problems connecting. We took 10 minutes to connect for a 2-minute hearing.
And this is Mr. Smith.
Mr. Smith, is that you on the iPhone?
Yes, sir.
All right. Ms. Smith, are you there? And if so, you're on mute, so I can't hear you.
Is that better?
All right, Smith, both parties are present. Mr. Smith, the defendant, is present with his attorney, Kyle Quinn. This is a motion to enforce a section of the parenting time order, giving the father 7 additional overnights with the minor children in the calendar year. Said overnights may be consecutive or non-consecutive. Additional overnights can allow the minor children to celebrate special occasions with the defendant father, including, but limited to a week-long trip, a long weekend, an extra vacation, a special event, etc. Defendant father will give plaintiff mother at least 30 days notice and when he would like to utilize this time. It goes on to say the parties will attempt to work together to see if the requested days are feasible given the minor children's school and other scheduled activities. Neither party will discuss this request with the minor children until the dates are solidified. If the parties cannot agree to the defendant father's request, they will submit to mediation to try to resolve this issue. And if mediation is unsuccessful, the court shall decide the issue upon motion. Father gave mother notice in December, end of December, that he wanted to take the kids from February 16 through the 23rd, in essence, to go down to Orlando, Florida. I believe the kid's grandmother's down there. And ultimately received, after some going back and forth, said from the mother, said, I'm kind of interpreting your words, but that's fine, except the kids don't want to go, so I'm not going to agree to it. Isn't that pretty much what you said, ma'am?
I said, I initially, as soon as he asked, I said what we had scheduled, which is
I understand there was extracurricular activities. He is
and
taking a
school.
winter break. Yep. He is going to miss, I don't know if it's a day or 2, 3 of school. 4 days of school. I know his response was, you know, oh well, you've had to miss other days. I'm not really going there. Whatever. You've also said that the kids have basketball and banquets and this kind of stuff during that time.
Correct, which are
do the kids want to go or not?
They do not want to go, and
all right,
they're willing to tell you that.
All right, Mr. Quinn, I know what your argument is. You say it's a wonderful time. I agree. I mean, my kids would have gladly skipped school any day and time to go anywhere, but that's my kids.
Yeah, Your Honor, I think you cited and went through the exact provision in the stipulated order. We entered that 6 months ago. She signed off on it. These kids, we think they want to go, and they don't get to frankly call the shots. They signed this order. They agreed to it, that he would go. He's complied with it, and she hasn't.
Well, that's the only part of the order that nobody's really complied. I know you asked for mediation, but it states right in here, if the parties cannot agree on defendant father's request, they will submit to mediation.
Well, I think I can address that, and I think my motion did. If you look at Exhibit B, he sent her.
I see she refused, but she's not allowed to. You will submit to mediation.
Well, if we go now, I've heard nothing from her since we filed the motion. 0. I got no response, no reaching out and say, oh, now I'll attend mediation, nothing. And we need a court's decision today, because if it just kicks it to mediation and that's unsuccessful, then he's going to miss the whole trip, which is starting next weekend.
I understand.
He can still go on the trip if he wants. The kids just do not want to go.
Stop. You're not doing yourself any good. I'm just warning you. However, I understand what you're saying, but the court enforces its orders, and they will. Mother cannot simply say no. You could set up mediation today, and I'd force mom to go. However, I understand also what you're saying, and there is a provision in here that does not say he gets it automatically by just notice. It says if the requested days are feasibly given, the minor children's school and other scheduled activities. Okay. The parties will attempt to work together to see if the requested days are feasible given the minor children's school. And what about that? I mean,
Your Honor.
I mean, I'm just saying it isn't that he gets to get them as long as he gives sufficient notice. They got to look at the kids' schedules and stuff like that. All
Yeah,
right.
I would agree with that, and that was the intent. But it's these kids participate in activities year round, and they're going to have some impact to some degree on those activities. And just because they have a basketball practice or something like that doesn't mean.
I think there's more than a basketball practice. What I read is they're ending like their season and they're going to a banquet and this kind of stuff. And the only reason I'm giving the kids some type of a leeway of doing that is because these parties can't agree. They didn't go to mediation. They have to go to mediation before I'm even required to make any finding on it. They did. It says in here, we'll submit to mediation. And I got to enforce orders. And ma'am, you cannot not submit to mediation. Do you understand that? That's a court order you agreed to.
Right. Well, the way I read it was if there was nothing scheduled.
What do you mean? If
we
there
would
was
try
nothing
to
scheduled?
Like if we didn't have anything already on the schedule, we would go to mediation if we still couldn't agree.
No. How can you read it at that? It says if the parties cannot agree on his request, they will submit to mediation. And you say, no, I'm not going to go. That's just open defiance of a court order. And quite frankly, I'm saying that you will submit to mediation. Mr. Quinn, you can set up mediation with Miss Giordano if she can do it Saturday. I don't care. It'll be done by Tuesday. Ma'am, why can't you be there at any given time between now and Tuesday?
Basketball games on Saturday and Monday.
Okay,
But
well,
if it's during the day, that's fine.
during the day.
Yep. Except, yeah, Saturday there's games until noon.
Your Honor, my problem with that is, one, she should have done this before. As the court said, that's just straight defiance of the order that she agreed to. And two, if they show up to mediation, she just says, no.
I understand.
Same thing that she's done this whole
If
time.
she doesn't mediate in good faith, I'm sure he'll be back. Mr. Quinn, here's the biggest problem, is that this is not something that the dad automatically gets if he just gives him the dates, okay? And you tell me the kid's got some kind of activities all the time. I don't know, they're done with basketball apparently over the winter break. That's the end of it. What else are they in right after that? These are not, these are 14 and 12-year-old kids, all right? I'm not dealing with 7 and 3, okay? So that they don't really have that. I don't know how connected they are with all these events and what they want. And they might say, no, I want to go to, I've been in basketball this year and I want to go to basketball. And I've got a banquet and these are all the friends I've hung out with and stuff like that. I mean, are you?
Well, my response to that would be he's awarded these 7 floating days.
Yes.
And if it's always in some sort of activity, and she says, well, it's scheduled during the time they're in these activities, how is he ever going to have the parenting time that's truly awarded to him? The intent behind that was that we're going to minimize the impact, which is why he chose to pick the midwinter break. That was it. It is inevitable that it's going to cause, they're going to have some impact on the kids' multiple activities. That's it. My concern, Your Honor, is that, and based on her facial expressions during this hearing, I think she's going to stonewall him at mediation. As a result, he's going to miss the trip because she hasn't agreed, and we can't get back into before Your Honor before that ship has sailed. And then we're out of luck.
I'm not sure you want to get in front of me, but I'm going to set up an evidentiary here, a motion time for Wednesday, because mediation will be set in the next couple of days. And ma'am, you will show up at that. And you will, if I get from the mediator that you're not even acting in good faith, then the kids are probably going to go no matter what.
Right. Can I say something?
Yes.
I understand they have the midwinter break. If he wants the midwinter break, the Friday to the Monday, he could probably miss one practice and still be able to play in his games, but his games are Tuesday, Wednesday, awards on Thursday. And if he wanted that extended weekend, I would do that. But the boy is the leading scorer on his team, and he really does not want to miss his last game.
Well, but you got to negotiate in good faith with him. Obviously, Dad wants to take him to Florida, and that's different. And plus, Mr. Quinn is entitled to 7 additional overnights. Okay, said overnights may be consecutive, non-consecutive. It doesn't say that he automatically gets all 7 or whatnot. They were meant for a year's period of time where maybe he's got a family thing that he wants to do in Lansing, and that's not his time, so he gets an extra time there. That doesn't. It's a weekend. It's a whatever. This isn't. I mean, you're saying that she just automatically can stonewall everything. It says in here, it's not limited to a week-long trip, a weekend trip, extra vacation, a special event. The problem with putting in something like this is it's kind of out there, and it doesn't just say upon proper notice. Boom, he gets it. And no matter what, I'm just going from the 4 corners of the document that is in here. I didn't draft it. Okay, I didn't have anything to do with it. I'm just and I've gotten a lot meaner on the idea that just says people who put stuff in their orders have got to follow them, and they will submit to mediation. I'm giving you something that says she will submit to mediation, and I'm going to find a minute on Wednesday in which to have not an evidentiary hearing, continue this motion at that time if there is no mediated agreement. And it doesn't sound like there's going to be, and I'm not sure that I'm going to allow the kids to go. But maybe I should talk to them. Maybe I should, because it specifies in here, parties will attempt to work together to see if the requested days are feasible given the children's school and other schedules. Shouldn't have been put in there if we aren't going to look at the schools and other schedule.
I agree the document's written as it is, but it also states that he shall have those 7 days.
I'm not prohibiting him from having the 7 days throughout a year's period of time. Okay, he shall have them within the period of that if they're feasible. I can't imagine that there are not other times that are feasible that he can pick up a few days here or a extra long time there.
Maybe, but at the same time, this is a trip with his extended family to Florida.
I understand that. I told you in my world, in my world, my kids would be glad to leave. Even my kid who was so heavily involved in hockey, he would have taken off school, taken off hockey, and gone there because it'd be great. But that's not my world. I'm not doing it from my personal standpoint. From my personal standpoint, I would like the kids to go. All right, personally, but that's not what I'm here to rule on. I'm here to rule on legally. All right. And that kind of stuff was in there and is put in there, and I'm gonna, like I say, I'm gonna enforce mediation, go in good faith. If the mediator finds that there is absolutely no good faith, I suggest that maybe she'll be here on my motion time also. If you don't, but that doesn't mean you're gonna reach an agreement. What time can we do Wednesday?
We can do 2:30.
2:30 Wednesday.
Let me look at my calendar, Your Honor.
I mean, this is getting really crazy because I don't know if you got tickets, and for Pete's sakes.
Yeah, I got.
And
yeah,
I'm sure you do. I mean, you're not gonna wait till you get it one way or another.
Yeah. So just so I'm clear with respect to the court's ruling today, it's going to require the parties to go to mediation by the end of day Tuesday. The plaintiff needs to participate in that mediation in good faith. I can put both parties will participate. I have no doubt Mr. Smith will. And then we're going to have a hearing on Wednesday time.
Just a continuation of the motion on Wednesday at 2:30. I don't know what else to do. And I'm not trying to give you much hope on that hearing, Mr. Quinn, if the parties, I will tell you this, if she doesn't negotiate in good faith, even if they don't come up with an agreement, and I get the mediator saying she wasn't in good faith, that's going to weigh heavily. But if parties try and negotiate in good faith, I may, ma'am, when are the kids available?
They can be available, what day?
What, Wednesday? I'm saying, are they? When are they
Wednesday,
get-
he has a game in Birch Run on Wednesday
Well, what time?
at 5, but his bus leaves, he rides the bus there and they leave at 3. I mean, I could do any other day, like today or
You don't live here, do you?
no, I live in Saginaw.
I don't want to bring the kids over, but I'd like to hear from them one way or another what they want to say. Why don't you?
Yeah, they're happy to
Have they
talk to
told their
you.
dad? Except
Yes.
for you? Mr.
I
Smith?
know.
Oh, he's
No,
shaking.
I
his
haven't heard from
head.
my son.
What?
I heard from my daughter, but she's just said the same thing that Molly has said for whatever excuses. I think my biggest problem is the zero effort she's put forward in trying to make anything happen and just failure to reply or anything.
I replied
I
immediately
read
and
some
told you what
texts
we
and
had
stuff like
scheduled.
that, and she replied, and she just kind of basically said, "I'll leave it up to the kids," because one of your replies was basically, something like, "So you're not saying no," and I never saw her say no. She just kind of left it up to the kids, and she started out right away saying that there's events and school, and you said school, they miss for less than that when you took them. I understand. But then there are events at school. Maybe these events mean a lot to the kids. Maybe you got to know that they do. And maybe it wasn't a good time. Maybe it should be March 1st or something like that. I'm sorry. It's a crappy thing to be in, but I'm getting to the point, especially I'm going to enforce it with you guys, that you're going to have to follow court orders. And if it says mediate. And not, this whole thing is the last weekend before there. And I'm going to do my best, but unless she doesn't mediate in good faith, you better talk to your kids and see if they really want to go or not.
Your Honor, I have two more comments. I'll be very brief. One with respect to the children, we have concerns with respect to her spinning, her meaning the plaintiff spinning so much.
Of course.
And I know the court will be attuned to that when it does speak with them. And two, so I'm clear with the order. We're going to continue the hearing on Wednesday. 2:30 works on my schedule. I'll make it work. Get them into mediation with Ms. Giordano before then. And then I have simply because of her outward defiance of the stipulated order to return to mediation before even having to be here in front of the court on that issue, we would request fees on that aspect.
I'm not going to give fees. I'm going to reserve fees right now in case I need to look at somebody. If I need to look at her later, I'm just going to, you got to follow court orders. You understand that?
Yes.
I'm not going to play games. And they're court orders. They're not suggestions. Right. And I didn't even draft it, and you guys did the drafting. Okay. So I don't expect him to say, well, let's go to mediation, because it sounded like he was being reasonable and you said no. And that does bother me a lot.
Okay.
So, Monday or Tuesday or something, ma'am, I got to figure out how to try and ask your kids something without you being there. I know that chances are you're going to tell them what to say, but try my best to figure it out. Mr. Smith, you need to talk to your kids also. Do you have them this weekend?
No, next weekend is my weekend when I'm
on
Florida trip.
All right. I need to try and figure out how to talk to your kids alone.
I tried calling them last night, but they both sent me to voicemail right away.
Ma'am, how do I get?
I can have them call him, and I can give you their numbers or give them my phone to set up a Zoom and leave.
You're not here next week. Setting up a Zoom for them.
If we did it on Zoom, I can do it on Aura, which is what
I could have them do it at school I could let them bring their phones to school, and you could do a Zoom meeting there during a
Do they
break
know how to
or
do
something.
that from school at that age?
I mean, if I could put Zoom on their phones, and if you guys send a link like you did, it kind of just hooks up. I could have a teacher help them and then get them in a room.
Well, when do they come home on Tuesday?
Tuesday, the bus like 3:10. My son will have practice, but it's at 4:30, so I could have him come home and then bring him back. He usually stays after, but he could come home if we could get that done.
At like 3:20 or something?
Yep, 3:20 on Tuesday.
All right. They're gonna be required to be in a room that you're not in.
Yep.
I mean, I'm real skeptical, and I understand, Mr. Quinn, what I'd be, if I was both Mr. Smith and you, I'd be very skeptical, but
Yeah.
I don't think I don't know any other solution. Okay. And if the kids want to stay home because they don't want to miss some important extracurricular events that they've been involved with for the year, that's what happens.
Well, the kids don't get to call the shots, though. The parties agreed that
I'll make the decision. Okay. But in this particular case, the way this provision is written, I think it's important that I find out if it is feasible, given the minor children's school and other scheduled activities. Other scheduled activities is what got you. Okay. School, I'd say they can miss school those days, if need be. Sorry. You get your 7 days, but you might not get them now. I will schedule Tuesday at like 3:30. Is that a good time or is that too late? Tuesday at 3:30?
No, 3:30 would probably be best, yeah.
I'm gonna at least talk to the kids some. Dad, you might, she said she'll have the kids call you later today. Or you can call them. All right, Mr. Smith?
Okay.
Now, Mr. Quinn, you're gonna call the mediator. As far as I'm concerned, you can contact Miss Smith and tell her when it is, even if it's later today or Saturday or Monday or Tuesday.
Yeah, I will reach out to Ms. Giordano to see what availability she has.
All right, good luck. All right.
I'll prepare the order.
Thank you. We're adjourned. Wouldn't your kids want to go to Florida?
Yeah.
Even if Austin. DS, both parties are present, both Mr. Regalado and Mr. Kimball. Both parties have filed a motion for custody in this case. There was a judgment of support just entered a couple weeks ago that gave initial custody to mom without prejudice to a court determination on this matter. So quite frankly, I have to set up a custody hearing. Got nothing else I can do. I got to set up a custody hearing to determine who is appropriate for custody. Although I think instead of that, I'll probably send it to the friend of the court for them to do an evaluation first. Because nobody has to meet any change of circumstance or proper cause to have that custody hearing. So before I set up an actual hearing, I'm going to send it to the friend of the court for evaluation of custody, both legal and physical, and parenting time and child support. Both of you understand what I'm doing on that?
Yes.
Yeah, I understand. I got a couple questions though.
About me sending it there or what?
No, I was trying to do like bi-weekly with the custody, a split custody.
Well, we'll find out whether it's supposed to be or not.
All right.
I mean, they can recommend joint legal, joint physical. They can recommend you get 2 nights. They can recommend whatever they think is appropriate if you cooperate with them. My only question that I have now is what we need to do so that, ma'am, the kids are with you primarily?
Yeah, as of last month, yes, but Jaden has refused to bring me back my daughter. But yeah, they primarily live with me.
What do you mean? How long has the daughter lived with him?
She's been with him for about 3 weeks now, but before that, she lived with me the entire time.
There's some reason that they haven't returned the daughter?
Yes.
I'm asking him. What is that?
So she had a rash that wasn't being treated right, and doctor noted that if the rash wasn't treated right at the time, it was going to be turned into a fungi. And I just want to make sure she's straight. Like, they haven't got the proper care they needed, and that's why I was just talking about like at least split custody so they could be supervised so I can know what's going on. Because every time I get them, they're either sick, they have a rash, or they're improperly dressed.
All right, well, and what about Jaden? Is he going back and forth, ma'am?
I mean,
No, I'm asking her now. Is Jaden Junior going back and forth or what? Or have you got him?
I've got Jaden Jr. He did ask me yesterday if he could get them. He hasn't been going back and forth in between those 3 weeks, but he did ask yesterday. I did not get a response, but he did ask yesterday. And
Well, you two are being miserable parents. On this because the kids got to see both parents. They got to develop a bond with both parents, and you guys are busy trying to carve out a spot in the world where you win. I'm going to tell you this until we have the friend of the court, either the friend of the court order or until there's an evidentiary hearing. I think I'll give mom the children from 9 o'clock Monday morning through Friday at 6. Dad will have every Friday at 6 through Monday morning.
okay, so you said Monday.
You'll have both the kids in your care from Friday at 6 p.m. until Monday at 9 a.m. All right, every week. Mom, you'll have them from Monday at 9 a.m. and you'll give them back at Friday at 6 o'clock.
okay, understood.
It's almost an equal split, not quite, but getting close. You'll see them every week, sir. You'll have 3 overnights. Friday, Saturday, Sunday. She'll have 4 overnights.
Okay.
Ma'am, you
Yes.
understand that?
Yeah, I understand.
All right, so since he has them, how about Jaden goes to him tonight at 6, and then Monday morning you'll have both of them back to you.
Agreed.
All right, Mr.
All right.
Kimball, if you don't take that daughter back on Monday, don't look for any good things to happen to you in the future. Do you understand?
Yes.
That'll be Monday at 9 o'clock. Can you guys, whoever is picking, do you live very far from each other?
No, I don't believe so.
Can the person getting the kids will pick them up from the other party's house, okay?
All right, understood.
So that tonight, at 6 o'clock, Mr. Kimball will come and get Jaden from you, take him home. Monday morning at 9, you'll go get the 2 kids back, okay?
Understood.
Mr. Kimball, you understand that?
Yeah.
All right. Maybe you guys can start acting in the best interest of your children, because that's what I'm gonna do. Good luck. We'll see you. Oh, you guys work? You make much money?
So
Yeah,
right now,
I work in healthcare right now, at retirement home.
Well, see, normally for the friend of the court, it costs $150 from each party to do that. And if you tell me you can't really afford it, I'll waive it.
As of right now, I can't. If you could please waive it, I'd really appreciate it.
Mr. Kimball?
you said 150.
Yeah. If I'm gonna waive hers, I guess I should waive yours.
All right, then you can do that.
All right, I'll waive your fees. The friend of the court's gonna contact you, and if you don't respond to them, they're gonna do their job anyhow, but without your input, and it doesn't ever turn out very good. You understand that?
Yes, yeah.
So, ma'am, I'm not asking your full address because we're on YouTube, but is it 1033?
Yes.
And sir, yours is 4636?
Yes.
All right, I'll be in touch with you there. Cooperate, or it doesn't go good. All right?
All right.
Thank you so much.
Thank you. We'll get the orders out to you also. Thank you. Have a good weekend.
You too.
He's connecting. We haven't done number 9.
Hi, I'm sorry about that.
It's all right. It's all right. Are you driving?
Yes, I'm actually on my way back from an appointment. I'm actually about to park here now.
Okay, I gotta ask you to park, but I'll call the case. This is 22-5 B Tucker. Both parties are present via Zoom. This is regarding 5 children, as I understand it. Is that correct?
Yes, actually, it's been a 6th one added to the roster, but yes.
All right. There's a motion that mom says that she has custody, but you guys are engaged and she wants both of you to have custody.
Yes, sir.
Is that correct, ma'am?
Correct.
Then if you want him and you both to have custody, under the case number that you're dealing with, file a stipulation in order agreeing to both of you having custody. So you can get a form down here at the Legal Assistance Center called a stipulation in order. fill out what you want there on it and present it to the court, I'm sure that I'll sign it if you guys want to have that.
Okay.
Understand?
Yes, sir.
As far as father's request for child support, did you call the friend of the court to tell him you guys are living together?
Yes, Your Honor, we actually been talking to them a lot. We actually would just like something documented from you to help us, figure out what's going on and why it's prolonging the situation so long. We talked to them on numerous occasions, but
you need to contact the front of the court and tell them we live together, and the kids live with us.
Okay.
All right, and they should, and that you want both of you, if you both contact them and you both tell them that, they're living with us, we don't want any child support, they should at least suspend child support for the time being while you're living together. I'm gonna call the friend of the court about it too, but you need to call them. All right?
Yes, sir. It was to
Okay.
our understanding though, because I received assistance.
All right,
We went to the
That's-
friend of the court office and they instructed us
all right.
to go
What
through
assistance do you
process.
receive?
I get food stamps and Medicaid, sir.
Then I can't stop the child support because it goes to the state. I'm not allowed to.
Okay.
All right. As long as it's for state assistance, I can't stop it. If you get off state assistance, we can stop it, but I can't stop it as long as you're on state assistance because you owe the money basically to the state, because otherwise the people of the state of Michigan are supporting your kids when we got people out there who can support them.
Okay.
All right. You understand that?
Understood.
All right. Then get down here and file a stipulation in order regarding custody, although as long as nobody's fighting it, it's kind of like it's up to you. But I can't grant the child support request. All right, good luck. Have you set a date for marriage?
Okay.
No?
October. It's in October.
All right. I wish you the best. Good luck. Take care.
Thank you, sir.
Adjourn. Thank you. 375.
Thank you.
DM. Looks like you said that you mailed a copy of this motion to him.
Yes.
End of January, so he should have had enough time to respond.
Yes.
This is a motion filed by the plaintiff in this case that, quite frankly, is nothing more than she wants the divorce with children to be redesignated as a divorce without children. She says that there's only one child of this marriage. Is that correct?
Correct.
And that child, Anaya, is now turned 18 as of 1/27 of this year. So it is appropriate that we change this from a designation of a DM to a DO, since there are no more minor children of this relationship. And we'll send an order down to the clerk of the court to change this to a DO. All right?
Okay, thank you very much.
Thank you. Sorry for the long wait.
No problem. I was doing errands in the middle of it, so this is actually
All
convenient.
right. Thank you. Have a good day. Saavedra.
Yes, Savedra.
Saavedra versus Mr. Saavedra. This is a motion filed by the plaintiff. She says that the defendant claims minor child Donovan for taxes. Both parties have agreed to amend, so the plaintiff can now claim all three minor children. Need to have amendment completed for tax purposes. Did you send a copy of this motion to the defendant?
Yes, we hand delivered one and I also texted him a
When
photo.
did you hand deliver it?
The same day I filed it.
The one 2/1?
Yep, on the 1st.
All right. I've got you on the record saying that because you do say it was hand delivered on 2/1 in here, and if it was not, I couldn't hear the motion. However, you say that the two of you agree, correct?
Yes.
Then what you need to do, because I can't find whether or not the two of you agree on it, you need to come down to the court or get from somewhere a stipulation and order that says that you agree that you will claim all the kids on taxes. Both of you sign it and get it up to the court, get it up to me, and you can, and we'll enter that as an order, as long as I know you both agree. But he's not here to even say he agrees.
Okay.
Okay.
So I just need to come down and get a form for us both to sign.
You should get something that says it's a stipulation and order. Okay. That means that the two of you are stipulating, you are agreeing to it, and put in there, all right? Now, the other thing that I know that I believe that you can go is through probably through the IRS and file a form where somebody gives the other person the dependency, but that's probably more of a pain in the neck than getting this, okay?
Okay,
I don't know if you can get it online. I really don't know, but usually on the 5th floor, you can get something that's a stipulation in order. Both of you have to sign it and date it. And it would probably say, you know, we both agree that, mom, the defendant shall claim all 3 children on tax returns. I don't know if it's for this year only or for all years going forward, or I don't know what, but put in there what it is. Landon apparently is 18 at this point.
yes,
So I'm not sure if you're dealing with him at all or not, but that's what I suggest, because I can't make a ruling here because he's not even here.
okay,
So I can't, don't get me wrong, I'm not saying you're lying, but I gotta put stuff on the record and have him so that he would be here, and he's not. So that'd be the best way for you to do it. Okay?
okay, will
Any
do.
questions? Sorry about the long wait, but
That's okay. Just to do, am I gonna need to have that notarized, or do we just both sign it and I take it back?
I think I can trust that he won't sign it unless he wants to sign it. Okay?
Yes, correct.
There's usually nothing on there to have it. They have to be notarized. Oops, I talked to my clerk, who's really the one who runs this courtroom. And she said it has to be notarized. You can go to
Okay.
or something like that, okay?
Okay, that's what I thought. Thank you.
Good luck, ma'am. Thank you. Have a good weekend. Take care.
Thank you, you too.